Good afternoon. Noting the time, it's 1 p.m. This is Chair Albert Chang of the New Mexico Oil Conservation Commission, calling the meeting back to order. Picking up on the agenda where we left off, I'd like to call case number 25694, 25695, and 25696, consolidated cases for American Energy Resources applications for de novo hearing. May I have the entry of appearances from the parties?
Yes, Jonathan Samaniego, representative for American Energy.
Thank you very much.
Good morning, Mr. Chair, Commissioners, Council, and parties. Darren Savage with Aberdeen Shield, appearing on behalf of Alpha Energy Partners 2 LLC.
Thank you very much. It's your application, Mr. Samaniego, so I will turn to American Energy first, but I will say that same thing that we did this morning. I will like to stay away from the actual merits or the substance of what you're asking for here. I think we need to first discuss whether or not there's this motion is procedurally proper before the commission, because we've had multiple hearings on this already, and I'm not sure that the NMAC allows us to have any additional hearings for these cases. If I could have, so Mr. Samaniego, I'll turn to you first.
Yeah, Mr. Chair, if I could just address one point of procedure. And if we get to the merits, I just want to say that Alpha's expert witness, John Kaufman, is available for any questions, and he will testify under oath. And I also, as counsel for Alpha, am professionally required to answer truthfully and candidly before the tribunal. I am concerned, however, Mr. Samaniego, representing American Energy Resources, has no professional obligation to speak truthfully and has no obligations to speak truthfully on factual matters if we get to that point. Therefore, I respectfully request that for Mr. Samaniego's presentation that the OCC consider whether he should be under oath.
That's fine by me. You don't have Mr. Samaniego, you don't have a objection to swearing to tell the truth in this proceedings, do you?
I object to everything that Mr. Savage says.
Do you object to, well, do you promise to tell the truth, though, in this proceeding?
Mr. Savage has already, under evidence, has already been untruthful. For him to make any kind of attempt that Samaniego hasn't been truthful and has to be truthful under perjury, it's all irrelevant, because the fact that Savage is the one who has been continued to pinkwash, manipulate the hearing matter at hand to turn this into a violation hearing of contortions, which is all irrelevant to the matter at hand. I object to Mr. Savage's statement and to consider them as moot.
I hear you, but the question is different. I'm asking whether you are.
And I'm going to go further. Based on New Mexico administrative law principles and cases like City of Albuquerque versus Chavez, an agency that has violated the law should generally not act as a hearing officer in the matter where it has a clear conflict of interest or bias, which the division and the commission under evidence have already shown bias in their orders. They have already failed charge obligated duties to enforce New Mexico laws that they're obligated to follow, not contort, to follow. Therefore, that any determinations by the commission, by you, Mr. Chang, or any division, Jesse Tremaine, that it's all moot. And the reason for that is because you guys have all, under evidence provided by American, have all violated your charge obligational duties to protect core elective rights, prevent waste, and protect the public and in the environment. You guys have already shown
clear. I would move that Mr. Samaniego, it refuses to be candid and speak truthfully before the commission.
Would be more biased and continuous violations of New Mexico law.
Thank you.
At the very minimum, I will ask all parties to try to speak one at a time for the court reporter. If let's not have contempt for the court reporter, even if we may have feelings about other people on this bench. So
I,
if you would
I
like,
must please, this matter should be going to the Attorney General. There's too many violations that have took place.
well, first let me, since we had overlapping conversation there, I will let Mr. Savage finish or repeat what he just said, and then I will weigh in.
Mr. Chair, respectfully, I think Mr. Samaniego has made it clear that he will not speak truthfully to the tribunal, and he will not be candid. He refuses to be under oath.
Object.
And
Savage is
therefore,
manipulating.
I think he does not have a right to proceed with this motion and should be denied.
Putting a pin in that issue, Mr. Samaniego, I'm hearing that your position though is, aside from the issue of whether or not you are willing. Let me finish and I'll give you a chance to respond, Mr. Samaniego. I'm hearing that you don't believe that your issues are or that this forum is appropriate for the issues that you want to bring. So if that's the case, and you're I guess I'm wondering how I might be able to grant you or any sort of relief or entertain your motion if you don't believe that this tribunal or this forum is the right place for you to be at.
Okay, gone by previous statements by you and the commission. Prior statements of you guys at the last hearing was that you didn't review the hearing matter because they were too tedious or too long. Therefore, they weren't reviewed. I'm going to say because of previous acts and admittance of non-reviewing matters and attempting to have determinations on unreviewed matters, it therefore creates more pinkwashing, more diversion from the actual matter at hand, which is ownership. So let's go ahead and go through this response that American filed. It's going to be a while. We'll go ahead and start with number one, and we'll go through the tribunals. Okay, so Alpha second formal response is procedurally improper because the subject cases of the record, and you guys be patient, I got a long one to read here. The record and orders of the cases approved by the division were biased, arbitrary, and capricious to officially act erroneously to approve and close cases in violation of numerous New Mexico laws.
Sir, I need to interrupt you because we need to, if you're going to read stuff into the record, well, that's, I mean, I'm willing to give you some time here, but I gotta have you be willing to say that your representations are going to be truthful, and B, I'm still not sure that how to resolve the issue where you've stated on the record just a few minutes ago that you don't think this tribunal is competent to resolve your issues. I believe I heard that.
It's not because you guys have already failed at your obligated duties. How can you justify failing your obligated duties to prevent waste, protect core elective rights, and prevent the public and the environment from harm, which you've all failed under evidence presented by American? How can you justify you violating New Mexico law? How can you justify that? How can the commission, the division, and the attorney Tremaine justify violating New Mexico law that you all are obligated and charged with to follow, not contort, not manipulate, not have personal opinions of agendas, to follow? How can you justify that? Violations are clearly been done. It's been stated with evidence presented. Alpha violated the C-145s 2.5 years. Nothing was done. Continue to violate. Filed plannings. Fraudulently gave wells away to avoid liabilities. These are all fraudulent acts to attempt to defraud an agency. Alpha defrauded the agency and manipulated the agency to abate to its own acts.
I will ask once more whether you're willing to.
How do you justify? How do you justify? I'm asking you, Mr. Cheng. I'm asking you a reasonable.
I will ask once more whether you're willing to attest that your testimony here today will be truthful. If you're unable to do that or unwilling to do that, I'm afraid we'll have to move on to the next case.
American agrees to talk truthful under purge. I've already admitted to that. Okay, I admit I'm going to be truthful. But you have you are irrelevant to hear this matter because you've already violated law. You're violating law to hide your agency's violations.
Thank you. So I believe I just heard Mr. Samaniego say again that we're not a competent tribunal to hear this case. Mr. Savage, I believe you are of the same position that this is also not properly in front of this this forum.
The
Yes,
commission is manipulating.
I do
The
believe
commission is manipulating
that-
the applicants. The applicants.
Mr. Samaniego has forfeited his right to have an adjudication before this, but he initially availed himself the jurisdiction of this court, and therefore, the commission now has sufficient evidence, and the division has sufficient evidence admitted into the record to rescind his 145s for his 3 wells, the Sake well, the Tip well, and the Rio.
I don't think we need, I mean,
I just want to state that as if you don't mind.
I think we can, I mean, if neither party thinks this case is properly in front of us and we don't have jurisdiction under 1915-3, and if Mr. Samaniego has stated multiple times on the record that we don't have jurisdiction for reasons that I don't quite fully comprehend, but that he's stated that position multiple times, then all parties agree that this is not properly in front of us, and therefore I don't know how to entertain it further.
Yes, I think that's a fair decision, Mr. Chair.
And Mr. Commission Counsel, would you like to weigh in any further on that?
No.
If that case, commissioners, any objections to us to the fact that the parties unanimously are both feel that this tribunal is not the right forum for their concerns?
No, Mr. Chair. No problem, Mr. Chair.
Well, due to lack of jurisdiction, I will dismiss the motion in front of me and proceed on to case number 24683.
Thank you.
All right, I believe we're now on case number 24683, which is the Welk application for rulemaking to amend a series of NMACs related to well bonding and other matters. I've got a couple of things on here that we need to go through. There may potentially, just in case there's any miscellaneous post-hearing matters. I know that there was interest raised by at least one of the parties to have this commission review the hearing officer's order on expedited joint motion to reopen. So I'd like to start there and just before I open it up to the parties though and have a free for all, I'd like to turn to commissioners and see if the commissioners are simply comfortable with the hearing officer's order, whether they wish to add any additional thoughts. If commissioners have questions for parties on that matter, I will open it up to the commissioners at their pleasure.
Mr. Chair, I think it would be helpful to have a conversation about the impacts of HB 80 on these proceedings. I think I generally agree with the hearing officer's position that we don't need to reopen the evidentiary portion of the proceedings, but and then I do agree that this is something we can take into account, given that we heard some substantial commentary on what its impact could be here. But I think spending a little bit of time on it could be fruitful.
Please go ahead. Now's the time. Oh, please.
All right, give me a second to get ready here. My questions, I will give everyone a swing at this, but I'll maybe begin with Namoga and we could go to IPA&M from there. On the impact of HB 80, which provides more funding for the reclamation fund. I guess my question would be, what's to stop future legislation from sweeping the fund and reducing any contribution, or sweeping the fund or reducing contributions to the rec fund in the future, as has happened in the past?
Sure. Thank you, Commissioner Bloom. Miguel Suazo appearing today on behalf of the New Mexico Oil and Gas Association, joined by my colleague, Dionza Valencia. And, you know, I think HB 80 has significant implications, short and long term. Obviously, the rulemaking that is in front of the commission right now is in large part predicated upon the lack of fundings in that reclamation fund. And the Legislative Finance Committee report that was referenced by the applicants and the division throughout this proceeding indicated that this is a sort of statutory change that is needed for to properly address the orphan well issue. And Namoga and industry have been clear that the current rulemaking does nothing in the long term to actually deal with the orphan well problem. Now, I want to caveat by also being clear, the industry has never taken the position that the passage of HB 80 does not make bonding necessary. But the passage of HB 80 does make it necessary for this commission to put on the record and provide justifications for why the bonding at these levels is necessary. And HB 80 is a significant development that we think the commission should take seriously. We've asked for calibrated bonding, which the current rules require based upon depth, age, condition, and things of that nature, all things which are in the record. So with that preface, Commissioner Bloom, I would say that there's nothing that prevents the legislature from so acting in the way you described in the future. But I do think that it would take a significant legislative undertaking to make that decision, given where the state has gone on this orphan well issue, and given the importance that it is, the importance to address it that the state has and the industry also has. And so they specifically made this fund now irrevocable. And I think that's an important message that we need to process and assess as part of our consideration of this rulemaking and determining whether or not the rules are actually calibrated to address the problem that's at hand. It is industry's position that HB 80 does create a significant change of circumstances that should be assessed in the context of where we've come on the record, and that the commission should weigh that impact, because I think that if these bonds are no longer calibrated to that problem as a result of HB 80, which was identified by the legislature, it was articulated in the report, which is on the record, and all we're asking for is for the commission to make sure that any bonding that is ultimately adopted is actually reasonably calibrated. And the commission can continue to do that going forward based upon, changing needs and changing circumstances and different well conditions. But I think fundamentally a flat bonding structure is something that no longer fits the bill in light of HB 80.
And,
Go ahead.
And just maybe to segue off that, and everybody can speak to this as well. I think you touched on this, but do you believe that HB 80 would prevent wells from becoming orphaned?
So I don't think that HB 80 itself prevents wells from becoming orphaned, right? And that's why the bonding is still necessary. But what HB 80 does do is it creates a tool for the state of New Mexico to address this legacy orphan well problem. And these rules are calibrated and justified to this commission to address that legacy orphan well issue, which now has a very significant sum of money behind it, which will be put in place over 10 years. And, I can get into this in my closing summation in greater detail, but HB 80 is going to allow the state of New Mexico to address 5 or 6x the amount of orphan wells that the division's been able to, undertake in a given year. So there's a very, significant development and mechanism to address that problem. And as a result, we think the commission needs to examine that impact and assess whether or not these bonding proposals actually meet the moment.
If I may follow up on the point and sorry to jump in on your questions here, but I've heard Mr. Suazo say calibrating the bond a few times, but you also mentioned that at least in Namoga's view, that the cost of well bonding and the cost of well plugging is dependent on well depth and well age, right? How does HB 80 change either well depths or well age?
Well, HB 80, I don't think changes well depths or well age. It provides a funding source to address legacy orphan well issues. And I guess theoretically, orphan wells that occur in the future, despite the fact that I think our bonding requirements have advanced significantly. And there's evidence on the record indicating that industry now plugs, something like 95% of the wells. And bonding is a big piece of that. So HB 80, I think, I guess indirectly, but still importantly, allows the state to deal with this issue. And if these rules are adopted as proposed, that essentially implements a long-term fixed and escalating cost on the industry, because they're going to be required to meet these bonding requirements. And if the rules are adopted as applicants and OCD proposed, some of the factors that go into assessing the cost associated with plugging and remediating wells and well sites, those are going to fall heavily on the industry at that fixed and escalating cost due to the CPI adjustments, whereas there's now a mechanism. So you can have the bonding piece of this. There's already a rulemaking from the land office for additional bonding. There's federal bonding. So we want to make sure that there's not duplicative bonding. And we want to make sure that if a well is, 500 feet deep, $150,000 bond is not something that's all you have. That's the only option. So we're just saying that we want it to be commensurate to the actual issue it's intended to address and not a whole cloth application to every single well.
There's a range of issues that you addressed there, but I want to drill down on this issue of calibrating the bond amount, right? Because that was your argument for reopening the record, is because if I understand you correctly, the 150,000 is somehow now, allegedly at least, impacted by HB 80. And I'm struggling to find nexus there because, again, if HB 80 doesn't magically make wells any younger and HB 80 doesn't make wells any shallower, then why would it have any nexus to the calibration of the bond amount here? Because I've got to find a prima facie nexus here in order to even get you a reopening of the record, right?
Sure. So HB 80 by itself is not the only solution that is, available. We have bonding in place. We have bonding reform that is being contemplated. What we have added to the record indicates that all these various factors impact the cost associated with P&A. And $150,000 is calibrated at the cost of that the division has indicated it costs them. Fine. But we've also provided ample evidence that those costs vary. Some of them are under $150,000, some of them are more. The significant driver of that is the depth of the well, the age of the well, the condition of the well. And so in places where the state does not have an operator to hold accountable, HB 80 puts a backstop in, which is also paid by the industry. So industry is paying for the bond if these rules are adopted as they are, and they're also paying into the reclamation fund. And so you're just basically stacking all these payments, which fall disproportionately, as I'm sure Mr. Cloutier can address in greater detail, on these smaller operators. And I think fundamentally, the commission needs to view this the way we do any sort of economic development in the state. It's important. We need it. Oil and gas funds our schools and everything else. I don't need to belabor that point. But I think the rub here is that HB 80 creates a significant tool to address these legacy issues and to address any orphan wells that occur in the future for which the state cannot hold an operator responsible. And if you start tacking on all of these other costs, keyed to CPI or whatever the commission ultimately calibrates it to, it's a fixed and long-term ongoing cost on the industry that doesn't meet the moment any longer because HB 80 provides another mechanism that didn't exist when this proceeding started, except for in theory. And so all industry is asking for is a calibration, because for these rules to withstand scrutiny over the long haul, whether it's on rehearing or in court, there's going to have to be a record that supports the adoption of the rules themselves. And I think given that the predicate for these rules in large part was the Legislative Finance Committee's report, the findings of the legislature, them expressly saying what statutory changes are needed, the adoption of something like HB 80 being one of them, the current record no longer reflects the current reality. And that is why we asked for this record to be reopened so that we could provide that evidence. The hearing officer has, I guess, recommended that, she doesn't believe that's necessary. But at the end of the day, the long-term viability and justification for these rules rests at this commission and on the decision and on the reasons they put forward on the record justifying these rules. And I just don't really think that without opening the record that you get to that point. And, either way, I think industry is comfortable with, whatever the commission decides. It's just that at that time, now a couple of months ago, we wanted to at least raise this as something for the commission to consider in light of a change in circumstances that we think impacted the rulemaking.
Yeah, and all I'm trying to do is drill down a little bit on the impact to the rulemaking, because circumstances change. The Strait of Hormuz is closed. Lots of things happening in the world every single day. The question is, how does this act really change? And I'm trying to get down to, and I'll give other people a chance to answer. And sorry to be taking up your time here, but that's where I'm struggling, because in order to reopen the record, what I'm trying to figure out is what exactly does HB 80 change about the actual individual well cost, right? Cost to, because whatever the balance in the rec fund changes already from day to day here, that we haven't seen that have a causal link and a nexus to individual costs to plug that well, right? Because I think we all agree here in this room that HB 80 doesn't somehow change the depths of the well out there, doesn't change the cost or the procurement vehicles that OCD has. So what I'm trying to get to is HB 80, what exactly is the nexus here that that would allow us, or that I'm trying to find a crux here that would justify reopening the record?
Sure. And, even if you don't decide to reopen the record, I think you can certainly take notice of HB 80, which you have, and you can assess its implications based upon my arguments and the other parties. But I do think that if the current rules are set at $150,000, which is tied to OCD's costs to P&A a well, and now there's a backstop for those costs as a result of HB 80, then the $150,000 bonding level no longer is commensurate to the problems described throughout this proceeding.
Wait.
Because $150,000 isn't necessarily the cost to the division, because there's a backstop to address those costs at present that wasn't here when it started. And because the cost can vary for OCD and for industry, all we're saying is that those bonding amounts should be calibrated to the actual well at issue, which might create some additional steps, but is still something that I think is more tenable under rules that are more finely crafted than the current ones that are in front of this commission.
Mr. Cloutier, would you like to also jump in, or would other parties like to weigh in?
Sure. Thank you, Chair Chang. Get back to Commissioner Bloom's original question, if I remember it. It's been a minute, but Commissioner Bloom, as I think you will remember, I think the land office and industry were in agreement at the legislature when budget crises of 15 or so years ago, when there was a sweep of the reclamation fund. Industry's always opposed that. I don't have a crystal ball, and I can't tell you what a future legislature is going to do. I would suggest you look at the fact that this was unanimous in both houses. Some pretty rare for an oil, gas, or mineral question to go through both houses unanimously and have the gubernatorial support. The other thing is that if the reclamation fund gets swept, bonds are no good either, because if the reclamation fund is empty, the division can't go and plug wells and then can't claim the bond under the bond form. So if that happens, everything falls down. I don't think there's evidence in the record on your follow-up question that bonding does prevent well orphaning. I don't think anybody here can predict what wells are going to be orphaned. I think we all know that wells are going to be orphaned in the future that aren't on the master orphan well spreadsheet. And what HB 80 does is gives the state the ability to use a tax imposed on industry to have all of industry pay for the problem, and you don't go impose additional costs on operators who are working hard, but today probably doing better because the price of oil is better, but who knows what's going to happen 6 months from now. But posing these additional costs on them for people who are going to comply with the rules anyways, my belief is that if somebody's going to orphan a well one day, it doesn't matter if you've got a bonding requirement on it. They're going to keep going and not bond it until they're forced to orphan it. But so I don't think it does prevent orphaning, but I think what it does is it fills the gap that was put forward in applicant's case in chief, that the reclamation fund's never going to be sufficient to do this. We now have a unanimous legislature and a governor who agreed with it. And like you, I never want to see the reclamation fund swept again. Didn't like it when it happened in a prior administration and wouldn't like to see it in the future. But you can be sure of one thing: industry will bring its powers to do its best to prevent a legislature from doing it like we did in the past. So I don't know, Commissioner Chang, if I address some of your follow-up questions as well, but that's and all we want to do to reopen the record is we have some supplemental testimony from Dr. R. Scott. It's already ready to go because we didn't know what was going to happen. That better explains to you how this works as a fix, and we don't. That's what we want to offer. And if the division or the applicants wants to counter it, then I think they should be free to do so. But that's what we have. For IP&M's point of view, that's what we want to reopen the record for, is just to put that testimony in. So,
Any other parties want to weigh in on this, or?
Thank you, Chair, Commissioners. Good afternoon. It's nice to see all of you. Thank you for your time and your attention. I'm Tanis Fox, a lawyer with Western Environmental Law Center, representing applicants, along with my co-counsel, Morton O'Grady, Kyle Tisdale, and Matt Nikhil on virtually. Just to briefly address some of the points that Mr. Suazo and Mr. Cloutier made. First, from the beginning of, I might remind everybody that the record has been reopened to take evidence of HB 80. The hearing officer allowed two things. She allowed the HB 80 legislation and legislative documents to come in because they met the qualifications for what's called administrative notice. So the record has been reopened, and we did not object to that. That was actually our proposal, that these materials come in because they are relevant for the commission to be able to review. And we also proposed that there be allowed additional briefing on those materials. And so from our viewpoint, the reopening of the record to that extent, the additional briefing is sufficient, we believe, for the commission to take due consideration of those materials. We don't believe additional oral testimony is going to be helpful, and it's only going to delay this already very lengthy process. Second, throughout their briefing on this issue, which did come as quite a surprise, I might say, they've taken the position, they're trying to characterize our position that the predicate, in Mr. Suazo's words, for our rulemaking is that the reclamation fund isn't sufficient. That is not the predicate of our case. We never said that. We never had testimony that anything close to that. We noted in our testimony that the reclamation fund is insufficient. And it still is for the kind of liability that LFC is looking toward. But that is not the predicate of our case. And it's not the predicate of our case because, as Mr. Suazo now admits, HB 80 will not prevent orphan wells. That's a slightly differentiated position than they were taking in their papers. But that is true. HB 80 does not prevent orphan wells. But you know what will prevent orphan wells? Our proposals. And one thing that will prevent orphan wells is bonding. Contrary to what Mr. Cloutier said was, if a well is going to be orphaned, it doesn't matter what the bonding is. It absolutely matters what the bonding is, because if a well is going to be orphaned and the state has sufficient funds to plug and reclaim that well, then that makes the state whole. But if bonding is insufficient, then the state isn't made whole. So it absolutely makes a difference what the bonding is. This idea about calibrating the bonding, which the chair was inquiring into, really makes no sense for the reasons I think that you were exploring. But also, our bonding proposals, the most significant ones, are based on one well financial assurance. Under the statute, one well financial assurance must approximate the reasonable cost of plugging. It can't be calibrated to the reasonable cost of plugging. It needs to approximate the reasonable cost of plugging. And that's, we have proposed the average cost to plugging for OCD, which would include the various required statutory factors, because it is the average cost. It's $163,000, and we have proposed a number that approximates that. Admittedly, it's lower. If you want to do 163, go right ahead. And so calibrating bonding for one well insurance is not authorized by the legislature. Mr. Suazo claimed that HB 80, that the funding there is irrevocable. That's not true. The initial legislation required a supermajority for the legislation to be amended, and that was quickly dispensed with in the first committee hearing. So yeah, as I think Commissioner Bloom started out at the beginning, what is there to prevent HB 80 from being amended? What is there to prevent the legislature from raiding the reclamation fund as it has in the past? And the answer is nothing. Except the will of the majority of the legislature. And then just, let's see. One other thing, Mr. Suazo, I believe it was talking about all these added costs to operators. Maybe it was Mr. Cloutier, to operators, where they got this additional bonding. Now they got HB 80, and all these costs are adding up for operators. But HB 80 didn't add additional costs, additional tax to operators. The tax is the same. It's diverting the money to a different place. And so admittedly, our proposed financial assurance will result in increased costs to operators. And, we have fulsome testimony on that point. So I guess just, in closing, I think, the commission has allowed, I think appropriately so, information and briefing on HB 80. And I don't think additional information and testimony would be helpful.
So let me, thank you. And let me clarify, since I appreciate the correction there. Yes, the commission has taken administrative notice. So to the extent that this is to the extent the parties are nudging us to consider the sort of broad policy implications of whether or not this rulemaking is still good, sound policy in the broader economic context, happy to do that. And I think that's why the administrative notice was taken. What I'm trying to get to today as a gateway issue before we get to your closing arguments is just whether or not we need to revisit specific testimony in light of HB 80. And that's what I was trying to get at with, does HB 80 actually change the OCD's cost to plug the well? Because I think and there's disagreement otherwise, unrelated to HB 80 as to what the correct cost and whose cost it should be. But I'm struggling to see how HB 80 would change the individual witness analysis of what those costs are to plug a well, because HB 80 doesn't change the procurement rates at which OCD I don't think HB 80 changes private industry's costs to obtain contractors to plug a well in and of itself either. So I want to make sure we give this request to reopen HB 80 due consideration. And that's why I've been asking these questions, because I'm trying to figure out where is there a prima facie reason, whether or not we agree with beyond that, but is there a prima facie case here that HB 80 substantively has a nexus that changes the economic analysis on the specific well bonding amounts in the specific proposal in front of us? And I think I've flogged that horse to death already. So let me give my other commissioners an opportunity to explore some other lines of questioning.
I think my last question to the parties would be, when should a commission reopen a record or stop reopening a record or stop the evidentiary record? This rulemaking was originally proposed in June of 2024. So the legislature had a 60-day session in 2025 to act. Again, in 2026, there was no, we didn't see anything coming out clamping down on this sort of an effort. Of course, we're always going to have tensions between the legislative branch and the executive branch happening. I think the land office on this matter of reopening the record, asked the question, could we reopen the record to talk about new examples of companies shirking their plugging and cleanup obligations? Or, should we look at what the effects of newly increased wartime oil and gas prices are on companies and their ability to put up more significant bonds? So just sort of maybe a larger philosophical question about, when do we reopen a record? When is it finally closed? Do we reopen records? Things of that sort.
Sure. And, I don't think this needs to be a philosophical question necessarily. I think you raised some great points and great questions. I think for me as a threshold issue is, had HB 80 been in place at the start of this rulemaking, how would these rulemaking proposals have been packaged as being necessary for the commission to adopt? And I'm not going to debate Ms. Fox on what her witnesses said or how they framed their application and so on and so forth. You guys can read that on your own. But I think if you read, the first and second, third iterations of the application, I think it's undeniable that the LFC report and this orphan well issue is an overarching theme. And industry does not dispute that orphan wells are in fact an issue. But fundamentally, what HB 80 does, whether or not it changes the cost to plug a well or not, it's new law that didn't exist when this proceeding started. And I'm not going to get into the depth of the arguments that we put in our briefing on HB 80. You guys can read that for yourselves as well. Your counsel can advise you on it. Our courts have been very clear about when an administrative body needs to reopen a record to take into account subsequent developments. And I would very much encourage you to do that because I think that's important and that should drive your deliberations and guide your decision makings on this point. Because if they're not thoroughly assessed here, there's a chance they could be thoroughly assessed at some point in the future. And I think that, what you want is to have solid ground and justification for adopting the rules that you do. And, our opinion is that in places, the commission, if they adopt these rules, that goes beyond their authority to actually adopt them under the Oil and Gas Act and so on and so forth. All of those arguments have been there in our motion to dismiss and all the other briefing. But I think what's important is that this commission cannot disregard HB 80 or take into account its implications as part of its rulemaking. That's simply all we asked. And I think that information is now in front of you and we're here and, you guys are going to make the best decisions you can.
And Commissioner Bloom, to address your question, I view asking to reopen the record as rather extraordinary. The reason why IPNM participated in that request is that this rulemaking was proposed to address a gap in policy where there's an orphan well issue and an inability to address it. And the policymaking body for the state of New Mexico, the legislature, has since spoken since we closed the record in this rulemaking. And that's why we participated in it, because we view it as this is their policy response to the issue. And we think that this commission should consider that and what the real implications of it are. And again, our request or our intent on reopening was we've got limited, I think less than 10 pages of testimony, maybe it's 12 from Dr. R. Scott that we were going to submit and then let you and, him be subject to cross-examination. And if Ms. Fox or Mr. Tremaine wanted to introduce rebuttal testimony, we would consider that. That's our request on the reopening, but I do view it as extraordinary, but it's because of a significant policy response to the very question that was being put to this commission in the interim.
If I may, I'll try to be quick here. Jesse Tremaine for the Oil Conservation Division. Thank you, Mr. Chair and commissioners and parties. There's two different issues here. The HB 80 argument, what HB 80 effectively does is act as a safety net, and it takes funds in the form of a tax from newer, higher producing wells, higher producing operators, and redistributes that wealth to those that are those wells that are not being managed by responsible operators. That serves as a form of social safety net, and its aim is at ensuring proper and more timely plugging. However, the proposed rule speaks primarily, even though there was discussion of gaps in rec fund funding. That's one aspect, that's one part of the context that the commission should consider here. But the proposed rule seeks accountability of responsible parties and recovery of expended funds. And this is really important because this factors into legal argument, but it addresses the contention that industry parties are making that the legislature responded to the underlying policy concern that drove the rule. And it did not directly. It addressed part of it. But irregardless of HB 80, the Oil and Gas Act expressly grants authority for OCD to seek indemnification from responsible parties for costs of plugging above the financial assurance value. That's in 70-2-38B. We've talked about that extensively. So the Oil and Gas Act itself does not support the premise that the remedy for orphan wells is that the state just permanently accept responsibility for plugging. Operators are no longer responsible. Part of that responsibility is a necessary financial assurance. The intent and the purpose of the act, HB 80 did not get rid of those parts of the Oil and Gas Act. They're in addition to, it needs to be in both and, not an either or. The purpose is that we're focusing on is both that accountability and recovery. This is important. I heard I think procedural or order of operations type argument that if there's not money in the rec fund, FA amounts will not matter because the Oil Conservation Division will be unable to plug the wells to forfeit the FA. And that's not true. We talked about that somewhat during the hearing. It was a lesser focus. But the commission can certainly take notice of the fact that 70-2-14B clearly supports the argument that the bond amount absolutely matters. So if any of the requirements of the Oil and Gas Act or rules promulgated pursuant to that act have not been complied with, the Oil Conservation Division, after notice and hearing, may order any well plugged and abandoned by the operator or surety or both in accordance with division rules. So practically speaking, and in terms of the evidentiary basis and dealing with sureties, yes, the division has historically gone after operators and not sureties. Part of the reason this was discussed at length at hearing is because a lot of those financial assurance instruments are like $7,000-8,000. So we can make those demands and litigate with twice the number of parties to get $7,000 or $8,000, but we're still going to have to use the rec fund. So these two serve two very distinct purposes, and the HB 80 does not address the policy concerns giving rise to the petition. Thank you.
Oh, and I don't know if the applicants wanted to weigh in on when would a commission reopen the record, when's enough, et cetera, et cetera.
Well, our 3 weeks of hearing is enough. But Mr. Cloutier is correct that reopening a record, say if you were in court, is an extraordinary thing to do, and it happens only infrequently in the most sort of extraordinary circumstances. And so in our view, for the reasons I've articulated today, for Mr. Tremaine's reasons, for what we put in our briefing, this does not represent an extraordinary reason to reopen, delay, take evidence. We would most certainly want to put on our own witness, to rebut. But I think that, given the materials that have come into the record without our objection, given the briefing that's occurred, given this argument now, I think the commission has a fairly fulsome view of the impacts, if any, of HB 80 on this proceeding.
Mr. Chair, thank you. My quick question to Nimoga. So I've read through the brief and then also even to IPNM. I'm not sure if, let's say, additional witness, or let's say Mr. Ascott coming in to talk about the economics. In your briefing, I do not see anywhere you make the case based on the HB 80, how that is really going to impact the 150,000. You are not giving us any numbers. You're just saying that the 150 probably is higher. But even within that discussions, there's nowhere that you are giving us any concrete numbers. So my question to you is, based on the HB 80, how do you see, let's say based on the witness that you want to put on the stand, how is that going to change the 150,000 number?
So I'll let Mr. Cloutier address how his witness would be able to address the financial impact as a result of HB 80. I guess what I'll say, which is how I interpret your question and what it kind of portends and what it raises for you to consider, is that the statute currently requires you to take into account certain factors in assessing the cost to plug, right? And so $150,000 on its face directly just overlooks that, because it's just a flat amount. It doesn't matter if it's $1 million or if it's $10,000. It's just a flat $150,000, which as a result doesn't follow the requirements of the current rule, which is to assess various factors associated with the cost to P&A that well. just wanted to touch on that point. We actually didn't recommend a witness on financial impact of HB 80. I believe IPNM did, so I'll let Mr. Cloutier address that unless you have other questions for me.
Yeah, so based on Ms. Fox and Mr. Shemane's discussion, the premise of the whole rule or the hearing, it's not about, let's say, the 150,000, it's about how much it costs OCD to plug a well. So let's say if there is HB 80, does that really reduces the amount that OCD needs to plug a well?
Well, I think that requires an assumption that is what the statute requires. It is NMOGA's position that is not what the statute requires. The statute requires the reasonable cost to plug and remediate the well. It doesn't say the reasonable cost to OCD to plug and abandon or remediate the well. And so you're reading, not you directly, but to take that interpretation, you're putting words into the statute that don't exist. And I think Mr. Rankin and myself are going to get into that in greater detail in our closing, because those are front and center about industry's remaining issues with the way the rules that are in front of the commission are structured. And so I think that's an important point. You can't read language into the statute that doesn't exist. It doesn't say OCD's costs. And I'm not saying that those aren't a consideration or that they're not relevant, but that's not what the statute requires. If you want it to be OCD's costs, that requires the legislature to come in and say, yeah, it's OCD's costs. But, again, that also overlooks the complexity associated with the costs that impact how much it actually costs to plug and abandon these wells.
And Commissioner Ampoma, I keep forgetting to introduce myself before I start making comments. So it's my third comment, Andrew Cloutier Hinkle-Shaner, on behalf of the Independent Petroleum Association of New Mexico. My colleague Ann Tripp is online. First of all, Dr. R. Scott will not testify that the HB 80 does anything to the OCD's costs to plug. That's not the purpose of us seeking to introduce his testimony. What our position is, and recognize we have disagreements with council, is the statute, among other things, which Mr. Tremaine cited, allows the OCD to go after the operator for additional costs above and beyond the bond. If the statute didn't contemplate that the bonding would not cover the cost of plugging every well, then that provision is unnecessary. So, but Dr. R. Scott is going to testify more that the orphan well problem that's been identified by the LFC, which was front and center of applicant's case, and the projected numbers is going to be much more than sufficient to completely take care of the costs of plugging those orphan wells. And none of us have to predict them, and none of us have to hope that those people have bonded before they orphan their wells. So, but we're not going after the 150 with that. Commissioner Ampoma is the short answer.
Well, could you I'm sorry.
Yes, sorry. Go ahead.
Well, could you briefly, this is, so perhaps I didn't make my intent clear, but this is basically, I'm trying to treat this like a proffer, right? Because really the only thing that I think the commission already agrees with the hearing officer. There's no, correct me if I'm wrong, but there's no appetite on this bench, I think, to ignore HB 80, right? And we're happy to take administrative notice of the plain language of the text, of the signing statement, of any of the legislative publicly available public records there. The question is whether or not additional witnesses, Mr. Scott, is offering something that is in addition or beyond, or that whether that changed circumstance requires us to hear from Mr. Scott. So I'm trying to figure out what you're trying to get out of that witness.
Dr. R. Scott would provide additional information in addition to the brief financial impact analysis of the LFC, showing how many wells the reclamation fund is going to be able to address over time, over the 10 years, and that the legislative response to that is more robust than the problem that has been identified to date, at least the predictions of what the problem is going to do. And that's essentially what he's going to testify to in a nutshell. So
You weren't offering Mr. Scott to be able to address the question that Dr. Mpoma and I have about how HB 80 inherently changes the cost of concrete, the depth of wells,
we would not, Dr. R. Scott did not offer any testimony on those facts initially, and he would not offer those facts, any of those facts in his supplemental testimony if it was permitted.
Got it. Thank you very much. Okay, I think we've talked about that enough. I think it's up to the commission now. I'm going to turn to the commission. We can take this matter under advisement and just hold off on a decision, or we can, I'm comfortable. I think we've explored. I'm not convinced that Dr. Scott is going to offer testimony that is sufficiently of a close enough nexus that it's mandatory for us to consider. I'm comfortable with allowing council and parties to ask us to review the rulemaking in the context of HB 80 and its associated documents, and to make reference to and we're happy to take I'm personally happy to take administrative record of HB 80 and its associated public records. Commissioners, would you like to take this under advisement to deliberate on it, or would you like to make a decision so that we can move into closing arguments?
Mr. Chair, if I may, so like Ms. Fox said, the record already opened where there has been supplementary information that has been submitted to the commission. So I do believe that that is sufficiently enough, for us to proceed with the process. And I don't believe that Dr. Ascott will add anything to change the basis of, let's say, how the cost 150,000, was more or less brought forth. So I do agree with you that the supplementary information is enough for us to really support decision making. Thank you.
Mr. Chair, I'm in agreement with Commissioner Mpoma's position on this as well.
Thank you, commissioners. In that case, I will take a motion that we accept and concur with the hearing officer's ruling on this matter, admitting or taking administrative notice of House Bill 80 and its associated public records, but that we deny additional witnesses to comment on HB 80.
Mr. Chair, I so move.
Mr. Chair, I second.
Any objections from commissioners? Hearing no objection, so ordered. Thank you very much. And with that, I will now open the floor and turn to closing arguments. Actually, you know what? I think I'm going to do everybody a favor here and ask for a 5-minute recess. Mr. Rankin?
Before we go into break, I think all the parties maybe were wondering what the sequence would be for closing summation. So I'm wondering maybe we can set that up right now real fast and then take a break.
Sure. I had presumed it would be in the same order that y'all opened with, but if you would like to, I have no objections if the parties would like to negotiate amongst themselves over whichever order you would like it.
I talked to Mr. Tremaine, and as applicants, we would like to go first. And then, and OCD is jointly proposing with us, and then OCD. I believe the state land office is on the line, and because they're aligned with us, I guess my recommendation would be that they go next. My recommendation then would be for Oxy to go next because you're more aligned with us. And then I guess I would say IPAM and Avoca can duke it out.
Okay, we'll arm wrestle during the break.
Let's see that.
That's fine.
That's fine. I appreciate it. What's the time? We'll reconvene at 2:10. Thank you.
All right. Good afternoon. Welcome back. Noting the time, I'll call the commission back to order. We're still on case number 24683. I will invite the applicants to provide their closing oral summations.
Thank you, Mr. Chair, members of the commission. My name is Tanis Fox, and along with my colleagues at Western Environmental Law Center, we represent applicants in this matter. We thank the commission, the hearing officer, and commission counsel for the time and effort you have put into this complex rulemaking. We believe at the end of the day, the state of New Mexico, our communities, and our environment will be the beneficiaries. New Mexico, like other oil and gas producing states, faces an orphan well crisis. According to the Legislative Finance Committee, OCD is plugging authority for 700 wells. We'll likely need to plug 1,400 inactive wells, and more than 3,000 low-producing wells are at risk of being orphaned. That's over 5,000 wells. Unplugged wells can emit air pollutants, including methane, a potent greenhouse gas, and hazardous air pollutants that can cause cancer, reproductive disease, and birth defects. Leaking wells can pollute ground and surface water. Communities likely to be exposed to pollutants from orphan wells include historically marginalized groups. When an operator abandons a well, the responsibility for plugging falls to the state. According to LFC, the state's current and near future liability for plugging and remediation is between $700 million and $1.6 billion with a B dollars. As we just discussed, HB 80 will not generate the revenue needed to meet that liability. The responsibility for plugging thousands of wells should not fall to OCD with its limited staff and resources that are already stretched thin. Now, while production and revenues are high, is the opportune time for this commission to adopt rules that will help prevent the proliferation of orphan wells that LFC predicts. While industry finally acknowledges the crisis in its post-hearing briefs, it argues the commission doesn't have the regulatory authority to address the predicament. According to NMOGA, quote, "The commission's task in this proceeding is not to resolve the orphan well crisis. It is to adopt rules within the authority that the legislature has actually granted." Applicants don't agree with that pronouncement. We formulate it differently. In our view, the commission's task in this proceeding is to take on the orphan well crisis within the authority the legislature has granted. And without doubt, the commission has the legal authority to take meaningful action to stem the tide of the crisis. Applicants and OCD propose a three-pronged approach to address this complex problem. First, we propose increasing financial assurance for high-risk wells. Second, we propose rules to protect against high-risk well transfers. Third, we propose strengthening rules to prevent inactive wells with no future use from lingering indefinitely in inactive status. The package of proposals you have before you represents a productive collaboration between applicants and OCD prior to filing and throughout the hearing process. Regular consultation with the State Land Office, good faith negotiations with OCC pre-hearing, and 3 months of intense and, in our view, constructive negotiations with industry parties post-hearing. Applicants appreciated the opportunity to sit down with industry, and we believe we did our part to find common ground. Applicants' proposals are jointly offered with OCD and are grounded in the day-to-day regulation of oil and gas operations. Over the last 2 years, applicants' team learned a lot from OCD legal and technical staff, and we have adopted a number of OCD's proposals. The State Land Office fully supports our proposals, and so does OCC, with 2 exceptions. And as a result of negotiations, NMOGA and IPAM agree not to challenge all newly negotiated provisions based on substantial evidence. It should be noted that the party's stipulation does not prohibit challenges to industry proposals based on lack of substantial evidence. In that regard, NMOGA and IPAM witness testimony focused, you might recall, on objections to applicants' proposals, but there was exceedingly little testimony to support alternate proposals. In NMOGA and IPAM's closing documents, they now offer alternate proposals, many for the first time. Many are backed up with no or little evidence. In considering industry's proposals, the Commission should scrutinize them carefully to determine if there is substantial evidence in support. Applicants' newly negotiated proposals are highlighted in blue in Applicants Exhibit 89, which was attached to our post-hearing brief. Applicants Exhibit 90 is a clean copy without highlighting. Applicants also filed a full set of our direct and rebuttal exhibits and exhibits introduced at hearing, so the Commission can easily locate them. The Commission can download the full set of 90 exhibits in the shared Welk folder in the MNerd Center Stack platform that we all can access in this proceeding. As is evident from the blue highlighted provisions in Exhibit 89, the negotiations produced a wide variety of changes, big and small. The end product represents nation-leading rules to prevent orphan wells, rules OCD believes it can implement, and changes that respond directly to industry concerns. The revisions made post-hearing represent a carefully crafted set of proposals that are a result of give and take among the parties. Therefore, applicants and OCD request that the Commission adopt our final proposals as a whole. As to the merits, first, I'll address industry's argument our proposals will result in waste. Second, I'll discuss our proposals for financial assurance in Part 8. Industry parties once again challenge the Commission's authority to adopt some of those proposals. Lastly, I'll discuss proposals in Part 9 that protect against transfer of high-risk wells and proposals in Part 25 that require timely plugging of unproductive wells. Industry argues applicants' proposals run afoul of the Oil and Gas Act's goal of preventing waste. NMOGA argues, quote, the legally permissible amount of waste the OCC is allowed to permit under its rulemaking authority is 0. And OCD by statute must be seeking to produce every molecule of energy possible from each well before P&A. These hyperbolic claims were undermined by industry's own witness. During cross-examination, IPAM's expert, Mr. Ezel, walked back his claim that 0 waste is allowed under the Act. He acknowledged that no operator produces a well to the very last hydrocarbon, that each operator can decide when to stop production based on their own economic calculus and leave resources in the ground. Part of that calculus includes the cost of doing business, which includes costs for bonding. Section 72-14 of the Oil and Gas Act governs the Commission's authority to establish categories of financial assurance. The most fundamental rule of statutory construction is to look first to the plain language of a statute and give the words their ordinary meaning. If the language is clear and unambiguous, the Commission must give the effect to that language and refrain from further interpretation. The plain language of 72-14 is clear and unambiguous. First, it authorizes the Commission to establish categories of financial assurance. The Act does not limit the Commission in the type or number of categories it may establish. Second, 72-14 requires the FA categories include, but are not limited to, 3 specific categories. The 3 categories are not exclusive. The Commission may establish additional categories. The 3 required categories are, first, a blanking plugging financial assurance not to exceed $250,000. Note that the statute does not specify whether the blanket bond cap applies to active, inactive, temporary abandoned, or expired temporary abandoned wells. The statute is silent as to the type of wells subject to the cap. The second category is a blanket financial assurance for temporary abandoned wells that is no less than $50,000. Note that the statute does not require that the blanket bond apply to all wells in TA. The third category is a one well plugging financial assurance sufficient to reasonably pay the cost of plugging the wells. And I might ask, who pays the cost to plug the wells? That would be OCD. No, operators do not pay that cost. Note that the statute does not specify the types of wells a one well FA applies to. Finally, 7214 requires a fourth category of financial assurance. Wells held in TA more than 2 years must have a one well FA. In accordance with the plain language of that section, applicants' proposed FA categories include all required categories and establish new categories. We detailed the statutory basis for each of our FA proposals in our post-hearing brief at pages 3 through 4. In short, applicants propose 3 new categories of one well financial assurance for the highest risk wells and operators. The Oil and Gas Act mandates that the one well FA be, quote, sufficient to reasonably pay the costs of the wells. With that mandate in mind, applicants propose $150,000 for the one well FA, a cost that approximates the average cost for OCD to plug, which is $163,000. There's abundant evidence in the record substantiating that amount. Using OCD's average cost of plugging necessarily incorporates all required statutory factors, including well depth. Applicants' new FA categories are, first, low producing wells, which we formerly called marginal wells, which are wells producing less than 180 days and less than 1,000 BOE in 12 months. In negotiations, we agreed with industry to allow for a variance based on takeaway capacity. There is evidence in the record for that. The variance provision is carefully drafted based on OCD technical staff experience. Industry has offered other exceptions. These exceptions could swallow the rule and are supported with little, if any, evidence. Moreover, industry's slew of exceptions is likely to place a substantial administrative burden on OCD. The Commission should reject all other exceptions. The second category is all active TA and expired TA wells. These wells are not producing and are the very highest risk. The third category is directed at high-risk operators. Operators with more than 20% of their wells in inactive TA or expired TA status. Those operators must bond all their wells at $150,000 each. During negotiations, applicants and OCD agreed to narrow the operator level FA to these operators, to exclude low producing wells, and to increase the percentage as part of the package of agreements that included removing the number of days as a criterion for establishing presumption of beneficial use wells. This category targets operators who are at high risk of failing, and if they did, the state would have to take on all their wells. Taken together, requiring the highest risk wells and highest risk operators to bond close to the actual cost of plugging provides a strong incentive for operators to do their own plugging and clean up. IPAM argues that applicants' FA proposals punish good operators, but IPAM offers no proposals for OCD to distinguish good from bad operators. Financial assurance is a cost of doing business, not punishment. NMOGA and IPAM offer alternate FA proposals. IPAM proposes that one well financial assurance for low producing wells and the operator level FA be set, quote, in an amount reasonably sufficient to plug the well covered by the financial assurance. While this formulation mirrors the statutory language, it would require OCD to make individual determinations for literally thousands of wells, which is too administratively burdensome. In any event, there's no evidence in support for this proposal. NMOGA proposes one well FA in the amount of $75,000 or $25,000 plus $12 per foot. There's no evidence in the record that either of these formulas represents an amount reasonably sufficient to plug the well as required by the Act. $75,000 is less than half the average cost. And LFC found that the average per foot cost to OCD in FY24 was $43.85, more than 3 times the amount proposed by NMOGA. IPAM and NMOGA's proposals for one well FA must be rejected. Industry launches a dizzying array of convoluted legal arguments why various FA proposals from applicants at OCD violate the statute. There's not enough time to address all of industry's arguments, but I'll address a few. First, industry argues the $250,000 cap on blanket bonds applies to all active wells. They claim, therefore, that applicants' low-producing well category violates the statutory cap because those wells are active wells. But the blanket bond cap is completely silent as to whether it applies to active, inactive, TA, or expired TA wells. By rule, the Commission has now limited the cap to active wells, which it has the discretion to do. But for the $250,000 blanket bond cap to apply to all active wells and thereby restrict the Commission from enacting any other FA for active wells, the statute would have to say so. It doesn't. Industry would have the Commission add language to the Act as shown by the slide before you. But courts will not read language into a statute that it's not there. Second, NMOGA claims that the $250,000 cap not only applies to all active wells without exception, but somehow applies to wells in TA for less than 2 years. Again, that's not what the Act says. The Act says only that TA wells are subject to a blanket bond with a floor of $50,000. It doesn't say that wells in TA less than 2 years are subject to a blanket bond with a floor of $50,000 and a ceiling of $250,000. Again, language would have to be read into the statute as is before you. Third, Oxy and NMOGA put forth an exceedingly strained argument that a 2015 amendment to 7214 that has since been repealed should be used to interpret the existing statute. They argue that in 2015, the legislature amended 7214 to create a blanket bond category, the blanket bond category for TA wells, but accepted that category from the $250,000 blanket bond cap. NMOGA argues, quote, in doing so, the legislature expressly accepted TA wells from the existing blanket bond cap, which confirms that the cap applied globally, absent a statutory carve-out. The problem with their argument is that in 2018, the legislature repealed the exception language, as shown on the slide on the screen. It should go without saying that statutory language that has been repealed cannot be imported back into an existing statute to aid in statutory interpretation. In fact, the legislature's repeal of the exception language supports applicants' interpretation. In sum, industry's assortment of tangled and internally inconsistent legal arguments strain credulity, and the Commission should reject them, just as it rejected them previously when it denied NMOGA and IPAM's motion to dismiss applicants' FA proposals based on similar arguments. In Part 9, applicants propose provisions to better protect the state at the point of operator registration and well transfer. Well transfer in particular is a critical point in the life of a well, as LFC has recognized. Low producing wells are often transferred and sold down the value chain to increasingly less well capitalized operators who are more likely to walk away from their obligations and leave the state to plug and remediate. Applicants, OCD, and OXY negotiated revisions to Part 9 pre-hearing, and the parties further refined the language during post-hearing negotiations. Applicants' proposals first target high-risk operators with a history of noncompliance, and authorize OCD to deny operator registration or well transfer on that basis. Denial is not required, it is discretionary. Second, to guard against undercapitalized transfers, applicants propose that operators taking on new wells submit to OCD a plugging and abandonment plan that demonstrates that the operator has the financial wherewithal to take on the new wells. Any prudent operator should be able to make this demonstration, a demonstration that adds one more layer of protection against wells being orphaned. NMOGA and IPAM claim these proposals are outside OCD's authority, but commission rules already authorize OCD to deny registration and well transfers based on noncompliance. These additional requirements fall squarely within OCC's existing authority. Applicants' third set of proposals in Part 25 help ensure timely closure of wells with no beneficial use. First, applicants propose to establish a presumption of no beneficial use for low-producing wells, a very original proposal that originated with OCD based on staff's field experience. The presumption, which is rebuttable, applies to wells producing less than 90 BOE in 12 months. That's 1/4 of a barrel per day. LSC found that most wells shut down at 2 BOE per day. This new regulatory tool is designed to get ahead of the problem and require operators to plug wells that have no provable beneficial use before they become inactive. In that regard, another revision applicants made as a result of negotiations is to remove the qualification that beneficial use does not include wells used for speculative purposes. Industry objected to this qualification, and given the strong showing to demonstrate a well has present or future use proposed by applicants, the qualification is not necessary. NMOGA and IPAM offer their own definition of beneficial use that includes a host of uses that are vague, such as regulatory compliance and infrastructure optimization programs, and are not supported by substantial evidence. Applicants' proposed definition, on the other hand, is based on the existing definition of inactive wells that allows for a broad array of uses and has withstood the test of time. NMOGA and IPAM's proposed definition should be rejected. Second, applicants and OCD propose that inactive wells can be placed in TA only if the operator can show future beneficial use. If a well has no future use, it should be plugged. Many states require such a showing. The current rules do not require any showing of future use and can be easily manipulated. Based on post-hearing negotiations, applicants revised their proposals governing TA status and offer 3 significant changes. First, we propose allowing operators to demonstrate that an active well has future beneficial use without placing a time limit when the well must be reactivated. This is big. Second, the scope of activity that can demonstrate beneficial use is not limited, for example, to enhanced recovery. Third, the requirement for a public hearing after a well has been in TA for a period of time is not mandatory, but is required only if an operator, OCD, or a member of the public requests a hearing. 2 public participation requirements are the only proposals where OXY parts ways with applicants and OCD. Unplugged wells can threaten public health and the environment. The public has an interest in the decision whether an inactive well is allowed to remain unplugged and should be allowed a voice in that decision. Commissioners, thank you again for your time and effort. We leave you with no small task. Applicants believe adoption of our proposals will effectively tackle the looming crisis and protect the state, our communities, and the environment. We respectfully request the Commission adopt applicants and OCD's proposals as a whole.
Thank you very much. Unless commissioners have questions, I will move on to OCD.
Thank you, Femi. Please, the chair and the commission, Jesse Tremaine again for the Oil Conservation Division. So first, Ms. Fox did a great job of walking through several sections. We concur and echo the arguments and the presentations that she made. I'm going to wrap this up in a different format here. The process and goal of the post-hearing negotiations was a truly substantial undertaking. Given the party positions, a patently adversarial hearing, three-week hearing, case posture, it was naturally a very challenging room. We intentionally, to start out with, the starting point, we intentionally prolonged those discussions because all of the parties came to the table with meaningful discussion. I want to thank the industry parties for the depth and scope of those discussions. I'm not going to thank them for the motion to reopen and the subsequent motions, but the discussion in the room and the final proposal, I think, was a very constructive and informative discussion. We knew going into that discussion that it would not be possible for industry groups to drop specific legal challenges. Obviously, we disagree. We've prevailed so far on those arguments at hearing, and we maintain those same arguments. But we, and I believe the industry parties, engaged to find the most effective and agreeable proposal once we had more substantive industry input and feedback, red lines, proposals, et cetera, rather than the opposition witnessing the hearing. So in an effort to limit the scope of possible appeal to the benefit of all parties, we entered into this truly substantial stipulation. I've never seen anything like that. So during those discussions, the division recommended some changes, that were based on the content of the hearing, the substantial evidence and record at hearing. Some of those changes, which one was referenced by Ms. Fox already, the alteration to the criteria for the proposed presumption of no beneficial use in a vacuum would, I expect, be considered negatively by industry parties. But as part of the consideration and feedback from industry, the parties structured a package of proposals where I think we can all agree that relative to the original amended petition, the package is a preferable option. We feel that this amended proposal gives effects to the objectives of the various parties stated in that discussion and of OCD, and they minimize the impact on responsible operators. I will say that there is, from OCD's perspective, there is substantial evidence to adopt the final package proposal or alternatively the original petition. However, because the petitioner and OCD respectively presented significant evidence in the form of data, OCD experience, observations, et cetera, to support both versions of those proposals. However, I do, for the record, have to reiterate that the industry parties at hearing did not provide a record to support an alternative rule. In terms of the other procedures, we stand on the motion briefing, closing argument, written closing argument, and earlier comments from today, and won't belabor any statutory interpretation or HB 80 discussions, but at this time, I will just reflect for the record that we maintain the same arguments we've made and reserve those for the future if there's a potential appeal. So I see this as the commission has really three options as we've presented it to you. And door number one is to adopt largely the package proposal, the final proposal that the petitioners and the OCD are supporting. Door number two, if for some reason you don't like the package proposal, there is substantial evidence to support the original amended proposal. And door number three, of course, is whatever you want, something else. I do not want you to adopt door number three. Please don't do that. We think that the package proposal represents a set of changes that, as I said, the parties negotiated in order for those different provisions to work together in the most cohesive and coherent way possible. It took a very long and challenging time to get there, but I think that we did. At a high level, and I think I said this at the beginning of this hearing, and I want to reiterate that this is inactive wells, well plugging, surface remediation, reclamation, et cetera. All of these things that we talked about are FA is a multifaceted problem. It requires a multifaceted approach. Thus all the debate about the impact of HB80, et cetera. Our goals in working on and supporting this rulemaking were that operators should be chiefly responsible for plugging their own wells, that the rules should enable or should be updated to more enable OCD to effectively hold responsible parties accountable. Part of that is to enable OCD to enforce against appropriate, a specific subset of wells and operators prior to the point in time when the operator is completely insolvent and gone, complete abandonment. That's again, back to this presumption of no beneficial use. Another aspect of this is that financial assurance needs to be, as we discussed in terms of statutory interpretation, but phrased another way, meaningful and effective to target. Whether that is the unchanged blanket bond amount for compliant operators, or whether it's single well bonds that fit into one of the other categories. And regardless of the specific enforcement posture that the division would need to take, that financial assurance needs to be meaningfully connected and specifically tied to OCD's plugging costs for those single wells. Additional sections that I want to highlight are that operator registration, well transfer, and operator certification processes. These changes are intended to allow OCD to reasonably track responsible parties rather than parties transferring wells, not checking back in to update leadership or ownership interest, et cetera. And then a decade down the line in an enforcement posture, OCD does not have accurate information to track down those operators. Additionally, the temporary abandonment sections are intended to, again, avoid undue delay in the responsible plugging of wells that are appropriate to plug. This is similar to those, similar intent to those requirements for the presumption of no beneficial use and the deletion of the inactive well exceptions that in 5.9 where operators can just carry a certain number of inactive wells that escape compliance under the rules. So the final proposal is intended to target the worst offenders for enforcement. It's also intended to require appropriate operator planning. And thirdly, to insulate the state in the event, the inevitable event that some wells will be plugged by OCD and OCD has to seek financial assurance or indemnification. So the structure of those changes involved, and I think that Ms. Fox kind of provided some detail on this, but the structure of those changes in the final proposal effectively moved more of the most problematic wells out of other categories into the presumption of no beneficial use category, but they moved other wells, less concerning wells, out of the low producing well category, which is to the benefit of operators and reduces the number of single well bonds required. We believe that, as I've talked through these priorities and objectives, that the final proposal, one, comports with that statutory authority available to the division and the commission, and that it achieves those legitimate purposes for enforcement, accountability, indemnification, et cetera. We ask that the commission adopt the final proposed rules. Thank you.
Thank you very much. No questions, then I'll turn to State Land Office.
Thank you, Mr. Chair, members of the commission, Ari Baranoff on behalf of Commissioner of Public Lands, Stephanie Garcia Richard, and the New Mexico State Land Office. The Commissioner and Land Office strongly support the proposed rule amendments. Western Environmental Law Center's proposed rule changes are changes that OCD and that the state of New Mexico have been needing for a long time. We are grateful that Western Environmental Law Center brought these proposed changes to the commission's attention, and we're grateful to the Oil Conservation Division and other parties who constructively engaged in the rulemaking process. These rule changes represent a crucial change in approach to financial assurance and other aspects of regulating oil and gas operatorship in New Mexico by taking a compliance-based and risk-based approach, both to amounts of financial assurance and also to some of the other mechanical but crucial aspects of regulating operatorship, like well transfers. Operators who are an outsized compliance problem require additional financial assurance. Wells that are extremely marginal are much more likely to be abandoned in the sense of being left behind, not of being properly plugged and abandoned. Wells that are in extended periods of expired or even approved temporary abandonment, and certainly wells that are inactive, are much more likely to become orphaned, and as a result, reasonably require higher financial assurance and additional safeguards to make sure that the ultimate plugging of those wells and remediation and reclamation associated with those well sites doesn't fall on the public, but instead is internalized to the responsible companies. There's several other features of the rule amendments that we believe will provide much needed regulatory tools to OCD and will improve the landscape that all of us are working in several significant ways. So one is, as WELC and OCD have noted, limitations on well transfers when wells or other facilities are out of compliance. That seems like common sense, but it's actually groundbreaking because the current regulatory framework doesn't reflect any kind of cognizance of those issues and really needs to. There's other features of the rule amendments that will also be extremely meaningful, not just, I hope, to OCD, but also to the State Land Office as a landowner. We are on the front lines of the problems that this set of rule changes is intended to address. We deal with the legacy contamination and legacy inactive wells that irresponsible companies have saddled us with every single day. And these changes, including the requirement that there be reasonable disclosure about operators' other compliance issues through other companies that they owned, through other entities, the fact that operators may have had bond claims made against them. That all seems pretty straightforward and should be, but again, it took this rule proposal to actually prospectively put that into law. And we think these are all changes that are long overdue. And for those reasons, would urge the commission to vote to adopt and promulgate the version of the rule amendments that was submitted by the petitioner through its joint stipulation. Thank you.
Thank you very much. Any questions from commissioners? No questions. We'll move on to OCC.
Thank you very much, Mr. Commissioner. Commissioners, we appreciate the opportunity to provide our perspective here in closing. This rulemaking addresses important, legitimate regulatory goals, ensuring that operators maintain adequate financial assurance for well plugging and abandonment, protecting New Mexico's environment and natural resources, and preventing the proliferation of orphaned wells. OCC shares these goals and has actively participated in this proceeding in good faith, including engaging in months-long pre- and post-hearing negotiations that produced the joint stipulation that you have all heard about today and have been filed with the commission that reflect substantial common ground among the parties. As a result of those month-long negotiations, the parties have reached substantial but tenuous agreement / acceptance over numerous modifications to the petitioner's proposed rulemaking presented to the commission over the 15-day hearing. OCC appreciates the work from the parties that we've all undertaken to engage with each other and develop the negotiated rule language that, in our view, is superior to what was initially presented. But disagreements remain, at least as to the legal issues. And that is over particularly what legal authority the commission actually has. OCC respectfully submits that there are several key provisions in the petitioner's proposed rule that exceed the commission's statutory authority, and they conflict with the express provisions under the financial assurance cap in the section, in the statute, section 70-2-14. Now, as we said, alluded to in the alternative, if you disagree with our legal arguments, OCC urges the commission to adopt the negotiated language that petitioners have proposed in their final exhibits, particularly the core package of negotiated provisions. And with the one exception of that we ask that you adopt OCC's red line modifications addressing proposed hearing and notice provisions in the regulation governing the temporary abandonment procedures in 1915-25-13C2. I'll touch on that briefly. But first, as to the legal issues, under the statute, there are three categories of financial assurance. And the statute establishes applicable statutory caps and restrictions that govern them all. Petitioners propose to create two new categories for financial assurance that would address low producing wells and a portfolio operator category. That would circumvent the statutory cap on blanket bonding that's been set by the legislature. That's where the problem lies. Because the commission cannot adopt regulations that exceed its statutory authority, the commission must reject those categories or make them subject to the statutory bonding cap. Here, OCC's authority to impose financial assurance is completely dependent on the language under section 70-2-14. That authority is not unlimited. It's constrained. And as we know from statute and case law, the OCC is a creature of statute. It's expressly defined and limited and empowered by the laws creating it. It may not create a regulation that exceeds its statutory authority. Here, under the statute, which caps financial assurance for all categories other than temporary abandoned wells through a blanket bond at $250,000. That's a ceiling that was deliberately set by the commission, by the legislature, that cannot be raised except by further legislative action. So what does the rule do to violate that? Well, there's these two additional categories we talked about. The low producing well would remove active wells from that bond cap and instead require $150,000 one well financial assurance for each low producing well. Operators with 10 low producing wells, for example, would need $1.5 million in financial assurance, which is 6 times above the current blanket bond cap. The other category is the operator portfolio category. That would require operators with 20% or more of their wells in an active temporary abandoned status to obtain $150,000 per well financial assurance for every well registered to that operator. Again, an operator with 100 wells that meet the 20% threshold would need $15 million in financial assurance, which is 60 times the current blanket bond cap. In our view, the legislature has not authorized the commission to prohibit operators from electing the blanket bond option. There's nothing in the statute that prevents operators from electing to go under the blanket bond. And unlike the 2015 amendment that Ms. Fox referenced, that specifically authorized the TA or temporary abandonment status wells to exceed the statutory cap. No such authorization exists for low producing wells or operators meeting a portfolio threshold. The legislative history of this provision makes clear that the statutory blanket bond applies to all financial assurance categories, including any new categories adopted by the commission other than temporary abandoned wells. So look at the statute as it existed in 2014. I've highlighted the key provision. The Oil Conservation Division shall establish categories of financial assurance after notice and hearing. Such categories shall include a blanket plugging financial assurance in an amount not to exceed $50,000 and one well plugging financial assurance in amounts determined sufficient reasonably to pay the cost of plugging the wells covered by the financial assurance. So at the time, there were essentially, I'm going to say two categories. There was another TA category down there, but there were essentially two categories, and the blanket bond covered all wells. It didn't specify because it covered all wells. In 2015, the statute was amended, and in the green highlighting here is the language that was added, and the red is what was taken out. They've added clear language that accepted from the general mandate for plugging of $50,000, the TAs. So they made clear that the TA wells were no longer subject to the blanket bond. Instead, it created a floor for TA wells, which makes clear that the intent of the legislature was to have a blanket bond that was available for all wells. And here they had to accept the TA wells from that standard provision. That language held until 2018 when the statute was amended again to increase the statutory limit for the blanket bond to $250,000. So as you can see, that was the principal change. They did exclude the except for. Now, petitioners have argued that that was a substantial change, that the except for means that it's no longer an exception, that it's simply just a category, that the blanket bond imposed by statute of $250,000 is no longer, it's simply just a category, that the commission is authorized to, by rule, to issue new categories that are no longer governed by or limited by that blanket bond cap. But if that were the case, if that were truly the case, then that would render the $250,000 blanket bond cap completely meaningless and superfluous, because the commission could simply create new categories or amend its rules to expressly provide that any existing category is no longer subject to that blanket bond, which is not the intent of the legislature. Petitioners Exhibit 4 references the Legislative Finance Committee's report, Policy Spotlight on Orphaned Wells. They have highlighted in their exhibit some of the key findings from the Legislative Finance Committee, including the key finding that I've underlined in page 32, that makes clear that the LFC believe that while many of the changes that this body is currently considering would likely be substantial benefit, they also identified that, well, the commission is nevertheless limited by statute. So many of the rule amendments proposed here, because they're limited, is likely simply going to replicate its existing problems, which means that the LFC goes to why the LFC was recommending, first, that the legislature have to amend Section 70-2-14 to allow for increased financial assurance. The petitioner's position is simply that the LFC is wrong, that that's not the way the statute should be read. Our view is that it's actually correct, that the statute must be amended first before any rules can be changed. In the alternative, in the event that the commission rejects our legal arguments, we believe that the rules as modified and negotiated by the parties should be adopted by the commission. Subject to OCCC's legal arguments, OCCC urges the commission to adopt the negotiated package, with one exception. The commission should adopt OCCC's modifications to the temporary abandonment hearing and public notice requirement as attached in Exhibit D to OCCC's closing argument. The parties negotiated a revised T provision that lays out a great process. We think it's appropriate. It gives the right protections, and we think it should be adopted. The only area of disagreement is whether the rule should require operators to provide public notice through a newspaper for applications for 5-year extensions under the proposed rule and allow any interested person to request and participate in a hearing. And our view is that those two proposals should be rejected. Requiring public notice for administrative applications is an unusual burden under the division's existing rules. There are only 5 instances where it's offered. In fact, one of them that I've listed here and in our papers is in the case of a hearing. So really only 4 instances where public notice through a newspaper is required. And those are extraordinary circumstances where you've got open pits and closed loop systems where operators are seeking narrow exceptions regarding setbacks from waterways in occupied buildings, applications for injection permits or enhanced oil recovery permits under the Safe Drinking Water Act, notice of abatement plans to address water contamination in the Commission's role as a constituent agency of the Water Quality Control Act, and then also applications to permit surface waste management facilities. Those are the only instances where general public notice is required under the rules. We don't believe that an extension for a 5-year TA falls into that category. Under the proposed rule, no party is entitled to notice, direct notice, so constructive notice is not an issue, as it is in the case of hearings, where sometimes notice is required in a newspaper because the individual cannot be located. That's not an issue here because no party is required or entitled to notice. And 5-year extensions of TAs also do not implicate Safe Drinking Water Act requirements, nor does it rise to a comparable hazard level inherent in any other types of applications that require public notice. So the OCC should reject this proposal. The rule does provide for notice on the division's website, so folks who are tracking these sorts of applications can easily identify when they're up for 5-year extensions. The second issue we asked the Commission to reject and adopt instead OCCC's proposal is the proposal to allow any interested person to participate in a hearing for these 5-year extensions, to request or participate in the hearing. This would be an unprecedented loosening of the legal limits governing party status in the division's hearings that should be rejected. Under the OCD's existing rules, only a person with standing can request a hearing. Only a person entitled to notice or who has legal standing may be a party to a hearing. No other OCD procedure allows any interested person to request and participate in an OCD hearing. In our view, it serves no technical purpose that will further the goals of the Oil and Gas Act, but it will instead increase the administrative burden on the division and its public hearing docket, which are already regularly beyond capacity every month, requiring normal course applications for compulsory pooling and the like to be extended, pushed out month to month, which often potentially impacts, in my case, it has several times potential lease expiration deadlines. So at most, in our view, any interested person should be limited to submitting comments for consideration by the director, similar to what is provided for in the PIT rule. And under that rule, folks who have concerns can simply provide comments to the division director, who can then take them into consideration. But in our view, there's no basis to allow any interested person to participate or request a hearing. To wrap this up, OCC shares the Commission's commitment to ensuring that operators maintain adequate financial assurance for well plugging and abandonment, that inactive wells are properly managed, and that New Mexico's oil and gas resources are developed responsibly. Petitioners' proposed revisions, however well-intentioned, exceed the Commission's authority under the Oil and Gas Act. The Commission must reject those new financial assurance categories to the extent they would exceed the blanket financial assurance cap or make the new rules subject to that blanket bond cap. In the alternative, we ask that the Commission adopt the negotiated language by the petitioners with OCCC's red line submittal for the notice and hearing provisions under the TA proposed rule. I appreciate your time. Thank you very much for the consideration.
Thank you very much. I will turn to Namoka.
Thank you, Chairman Chang. Commissioners, good afternoon. Miguel Suazo with Beatty and Wozniak Providing the closing summation on behalf of the New Mexico Oil and Gas Association, I'd like to first start by thanking the commission for the additional time to confer with the parties. I think there were some meaningful discussions, and I think that we're able to identify a lot more commonality and at least, come to a better understanding of where we sit with respect to our perspectives on these rules as part and parcel of that process. We'd like to thank the parties for their commitment to working with us. And, we can certainly say affirmatively that where the rules are a better place than where they started. That does not mean that those rules are perfect. These are imperfect rules and, put together through an imperfect process, but that's the way it goes. And the commission has before it now the hard job of finalizing those rules for those of us who are going to be dealing with them going forward. So the threshold question here are what the boundaries of the statute are. And Chairman Chang framed this at the outset of the rulemaking. The commission must decide what the boundaries of the statute are. And that should be the organizing principle of deliberations. Under 1915-3-13C, the commission may adopt the proposed rules, reject them, or adopt them in part. But whatever the commission does, it must give reasons. Now, NMOGA's position is direct. Several of the proposed provisions must be rejected or materially revised because they exceed the boundaries of the Oil and Gas Act. Substantial evidence cannot create statutory authority. Now, the standard of review here is found under 70-212.2C and Rule 1-075. A commission rule is vulnerable on appeal if it is arbitrary, capricious, an abuse of discretion, unsupported by substantial evidence on the record, or if it is otherwise not in accordance with law. The relevant question for NMOGA's primary objection is not whether the record contains evidence of an orphan well problem. It's whether these particular rules are within the scope of the authority the legislature has granted.
I apologize. We're having technical difficulties. Give us a second up here. Our monitors are having difficulties. Appreciate it.
All right. So we put some legal authorities in our briefing, the Gonzalez case and Marbob, that make the point, I think, rather simply. An agency cannot adopt a regulation that exceeds its statutory authority, and a failure to consider an important aspect of the problem is independently arbitrary and capricious. Now, there was a stipulation entered into by the parties, and that stipulation was limited. Before turning to the merits, I'd like to make clear NMOGA's reservation of rights. The joint stipulation was limited. NMOGA agreed not to challenge certain negotiated provisions on substantial evidence grounds. NMOGA preserved every legal authority objection otherwise. And those preserved objections include arbitrary and capricious, ignoring an important aspect of the problem, lacking a rational connection between the facts and the choice made, statutory authority, ultra vires acts, conflict with the enabling statute, limited statutory purpose, including the prohibition on unlawfully promoting waste, due process takings, and other constitutional concerns, and the prohibition against punishing past conduct or imposing retroactive rules. And under the State Rules Act, no rule is valid or enforceable if it conflicts with the statute. A conflict between a rule and a statute is resolved in favor of the statute. So the commission should not treat the stipulation as an agreement and an indication that these provisions are actually lawful. We've said throughout that we feel this is the right goal, but the wrong tool. NMOGA acknowledges that New Mexico has an orphan well problem caused by legacy wells, and that should be plainly stated. But WELC and OCD have asserted in their closings that these proposed rules will prevent orphan wells, and there's no evidence of that in the record on that point. I think that we've identified the problem operators, and the problem operators are not the ones that are going to be subject to these rules. The proper legislative fix was HB 80, which reforms the Oil and Gas Reclamation Fund, and by NMOGA's calculation, HB 80 will plug roughly 5 times the wells that these proposed rules will ever plug, even assuming every operator complied. And we think that OCD has already conceded it does not believe 100% of operators will comply, presumably either because of failures to timely submit production reports or because they will not be able to. And these points were fully argued and preserved in NMOGA.
By the end of today. No. Okay. Well, yes.
All right. These points were fully argued and preserved in NMOGA's and IPNM's motion to dismiss, the reply, and the exceptions. So the real question before the commission is whether it can solve the existing orphan well problem by adopting rules that the legislature has not authorized. Next slide. Now, on this side, this cites to the LFC's recommendation to amend 70-214 to authorize new financial assurance categories for low-producing wells and asset retirement obligations based on transfer restrictions, and confirms that such authorization does not currently exist. The LFC committee, or the LFC, identified statutory gaps and recommended legislative amendments for several of the very provisions before the commission today. The LFC specifically recommended amending this statute to authorize new financial categories for low-producing wells and to authorize ARO-based transfer restrictions. By recommending the amendment, the LFC confirmed that such authorization does not currently exist. Welk and OCD rely on the LFC report, and that same report confirms what NMOGA has been saying throughout this proceeding. The right tool for these specific proposals is statutory change, not agency rulemaking. Where the Oil and Gas Act withholds authority, the remedy must come from the legislature itself. With these threshold points in mind, I want to turn to NMOGA's final positions on the revised proposed rules, starting with the operational picture before walking through each ultra-virus concern. Now, before turning to the statutory analysis, the Commission should appreciate the scale of what is being proposed. Well proposes a 437% increase in total financial assurance requirements and an 882% increase in single well bonding from $118.4 million to $636.6 million. And under the joint stipulation, those numbers are subject to CPI adjustments starting in 2032. All of this comes while the proposal limits the available sureties to those certified by the U.S. Treasury and listed on Circular 570, even though more than 70% of operators rely on surety bonds per OCD's Exhibit 29. There is also an open question whether plugging insurance has been approved by the Secretary of Insurance as expressly required by the Oil and Gas Act, which would leave only cash bonds and letters of credit. This proposal also fails to acknowledge OCD's existing discretion to waive plugging assurance requirements for good cause or where plugging is ongoing or planned. NMOGA's response is to counter with workable proposals while preserving statutory authority, which I'll walk through next. So let's take these in turn. Current single well bonding under the existing regime is $25,000 base plus $2 per foot of vertical depth applied to all well types. The proposed rules increase that to $150,000 for every individually secured well, regardless of type. Current active well blanket bonding scales are $50,000 for 1 to 10 wells, $75,000 for 11 to 50, $125,000 for 50 to 100, and $250,000 at the cap for 100 or more. The proposed rules raise that to $250,000 for any number of active wells, but at the same time prohibit blanket bonding and require single well bonding for newly created well types defined by the proposed rules. These new well types, low producing wells, and all wells in a high risk portfolio are still active wells protected under the Oil and Gas Act. And for temporarily abandoned wells, the current bonding for pending TA and TA plus 2-year scales from $150,000 for 1 to 5 wells up to $1 million for 25 or more. The proposed rules expand the scope of TA bonding to all TA, pending, approved, expired, and inactive wells. They eliminate this blanket bond option entirely by requiring $150,000 for every well that's secured. Now, on operatorship, Welk created a sweeping new operator certification that it would impose at registration and at every transfer. Namoga negotiated that down and accepted certain pieces for substantial evidence purposes. What Namoga did agree to was a limited post-hearing edition, a 5-year look back. I think Welk's proposed more than that, consistent with the existing burdensome operator disclosure requirement at registration. OCD did not indicate opposition because it is consistent with the existing regime. Now, what Namoga can't accept is expanding that existing registration disclosure, 25% or more leadership or ownership in a non-compliant entity over the past 5 years to apply. First, to every change of operator, which can occur many times over the life of a single well, and second, to require annual recertification by every operator every year, when leadership only needs to be identified annually under the current rule that is sought to be amended. Now, on compliance criteria under proposed Part 9, operator transfers and therefore well transfers are limited by reference to Parts 25 and 27. The disclosure regime then uses 1915-59A criteria to define a compliant entity. Namoga can't accept eliminating the existing P&A allowances under amended 1915-59A4, which currently authorizes a small number of wells to be out of compliance with P&A timing to account for ordinary maintenance and operational realities like changing operational status. Namoga also cannot accept the addition of a new compliance requirement under the proposed 1915-59A5, which would require Part 27 venting and flaring compliance by cross-reference. And just as importantly, Namoga cannot accept requiring Part 29 release and Part 30 remediation compliance by cross-reference for the transfer of assets, wells, and facilities under Part 9, when this rulemaking is limited to Parts 2, 5, 8, 9, and 25. So with this operational picture in mind, I want to walk the Commission through the specific statutory authority deficiencies, starting with the controlling FA statute itself. Section 7214A is the controlling statute for plugging financial assurance. It identifies the categories, the cap, the TA-specific structure, and the standard for one well financial assurance, and that is all it does. There are 3 categories: the $250,000 blanket plugging FA cap, the greater than $50,000 blanket plugging FA floor for TA wells, and the reasonable plugging cost for one well FA, which requires an individualized well inquiry. The Commission must start and end with this statute. That brings us to Mr. Rankin's rainbow. I did have visions of imposing Mr. Rankin's head on LeVar Burton's body, but I reconsidered. This is the slide that I would encourage the Commission to keep in front of it during deliberations. Namoga is not asking the Commission to insert a comma. Namoga is asking the Commission to recognize and give effect to the comma that's there. And that's the comma that the legislature placed. The penultimate comma in section 72-14A confirms that categories are separate and non-overlapping. They are not unlimited layers that can be stacked to circumvent the cap. And as further proof, OCD's own practice confirms it. Double bonding one well under multiple categories is not allowed. Mr. Rankin touched on the legislative history, and I think that that's critical to keep in mind because that history reinforces the point. In 1977, the legislature created the basic FA structure. In 2015, the legislature added specific TA bonding authority. In 2018, the legislature raised the active well blanket cap to $250,000. Now, this pattern matters because each time the legislature intended to create a new bonding category or to raise the cap, it acted directly. And no amendment since 2018 authorizes low producing well financial assurance, high risk portfolio financial assurance, or operator risk financial assurance. Moving to the next slide, covering the $250,000 blanket cap. Applicants in OCD have said that the act does not expressly require all active wells to remain under the blanket cap. But if the commission can define any subset of active wells and move them into one well FA, the $250,000 cap becomes meaningless. And New Mexico law does not permit a statutory interpretation that renders deliberate statutory language superfluous. So the first specific application, low producing well financial assurance. The joint stipulation renames marginal wells as low producing wells, but the legal issue here did not change. Low producing wells are fundamentally still active wells. The proposed 1915-89D imposes $150,000 in one well FA for each low producing well. And that creates a new active well financial assurance category not authorized under Section 70-214A of the Oil and Gas Act. In fact, nothing in the Oil and Gas Act authorizes the Commission to consider output levels in setting financial assurance, not even as one of the individualized well factors for single well bonds. The second specific application, the high-risk portfolio category, under proposed 1915-89E, creates a high-risk portfolio category triggered when 20% or more of an operator's wells are inactive or in TA status. It then imposes one well financial assurance across the entire portfolio, including wells that remain active or that would otherwise be eligible for blanket bonding. This is not an individualized plugging cost requirement. It is a portfolio-level bonding category that the statute does not authorize and that exceeds the active well bonding cap. It is also contrary to the plugging FA itself, which secures plugging and abandonment of a specific well. Whether a single well bond is required should not vary based on the number of low producing or inactive wells also designated by the operator. Next slide. There we go. So both of these new categories, low producing well FA and high risk portfolio FA, are contrary to plugging FA itself, which secures plugging and abandonment. Plugging FA is only cancelable when the well is plugged to the division satisfaction or replaced with other financial assurance. The number of low producing or inactive wells designated to an operator and the operator's overall production rate should be irrelevant to the plugging financial assurance inquiry. And there is also a surety market reality the Commission cannot disregard. Even if sureties could meet the proposed increases, the surety market would likely decline participation due to heightened regulatory burden, increased bonding levels, and underwriting uncertainty tied to the new low producing well and high risk portfolio classifications. So applicants in OCD say this is not a blanket bond because they call it a single instrument instead. The Commission should look at function, not label. If one instrument secures multiple wells and produces aggregate obligations far above $250,000, it functions as aggregate multi-well financial assurance. These are still active wells being unlawfully prohibited from the $250,000 blanket bond that the Oil and Gas Act statutorily guarantees. The statute limits substance, not labels. Section 72-14A specifically sets a $50,000 floor for blanket FA, but only for wells held in TA status for more than 2 years. And that trigger matters. It is the precise point at which the legislature authorized heightened TA financial assurance. The proposed 1915-89F eliminates that trigger by expanding the scope and subjecting all pending, approved, and expired TA wells to heightened one well FA, regardless of duration. That prohibits operators from using their active well blanket bond to cover approved TA wells in the first 2 years. So here the legislature drew the line. The commission division should honor it. Even if the commission believed it had authority to create these two ultra-virus categories which violate the legislature's express limits, the $150,000 amount fails independently. Section 72-14A requires financial assurance sufficient to reasonably pay the cost of plugging the specific well covered. It requires consideration of that specific well's depth, length of time since production, and costs of plugging similar wells. A flat $150,000 amount for all wells, regardless of statutory factors or any other relevant factors, is the opposite of an individualized inquiry. Now, we touched on HB 80, so I won't belabor that in closing, but just to close with Namoga's position, HB 80 does not eliminate financial assurance, and Namoga is not arguing that it does. But HB 80 does matter because the legislature chose a fiscal mechanism for public orphan well liability. The commission must apply current law, which HB 80 currently is. It cannot disregard HB 80 because a future legislature might change it. It is the law now when this rulemaking is pending. HB 80 undercuts the premise that the commission must stretch Section 7214A to solve a funding gap. And as a practical matter, one well FA amounts need to be recalibrated using post-HB 80 data. Now, on asset retirement-based transfer, review and denial, Section 72-6 limits OCD's authority to matters arising as a result of oil and gas operations. Property acquisition is not an operation. Operator transfer relates to who may conduct operations. The rule should not become an ARO-based transaction veto type of regime. And as I noted earlier, the LFC confirms there is currently no authority for ARO-based review and transfer restrictions. That is the same body the applicants rely on. The proposed rules effectively create a pre-approval requirement to prior acquisitions. The language is improved under the joint stipulation, to be sure, by referring to the specific change of operator provisions in 1915 9.9. But the commission should ensure in its deliberations that the final rule does not reach property acquisitions, asset sales, or non-operating interests. Plugging liability secured by FA arises when a well is drilled or when a party assumes operations, not from the property transaction itself, like an acquisition, and pre-approval requirements can create liability before a well is even spud. So any final version of the commission's order on the same should make clear nothing in 1915 8.9a authorizes OCD to approve, disapprove, delay, or condition the acquisition, sale, or transfer of property and property interests. Moving on to retroactivity, New Mexico treats a rule as retroactive when it attaches new legal consequences to past conduct. The Oil and Gas Act contains no express authorization for retroactive rulemaking. We referenced the Marker case for the presumption of beneficial use, which applies immediately for operators who are not substantially out of compliance with production reporting. P&A and change of operator requirements under 1915 25.9E for the first year of implementation, which means that the division will use pre-rule production, financial assurance, and P&A history as the operative predicate for the new plugging consequences. And the issue is presented not only by the presumption applying to so-called bad actors in the first year, but also by the low-producing well FA requirements for transfers, which was delayed to 2029 under Wilk's final proposals, the way other low-producing well requirements were. Now, returning to the compliance criteria from a statutory authority perspective proposed under 1915 5.9a, that does more than define compliance. In fact, it removes all existing allowances for a small number of wells out of compliance with P&A requirements under subsection A4, It adds Part 27, venting and flaring compliance under a new A5. It then extends that compliance framework to a FA release and operator transfer determination under 1915-812 and 1915-99. And the new facility, well, and asset transfer provision references releases and remediation under parts 29 and 30. This is, complex just to describe it, to read what it does, but this is not a minor cleanup. It changes the consequences attached to compliance status. And as a paradoxical result, it actually promotes waste, contrary to the Oil and Gas Act's mandate. Now, on waste and correlative rights, the Act requires the Commission to prevent waste and protect correlative rights. It does not authorize rules that predictably create avoidable waste. Rules that force premature plugging, abandonment of viable resources, or distress transfers cause underground waste, surface waste, and correlative rights harm. And violating correlative rights itself can cause or increase premature plugging, resulting in further waste. And to be clear here, NMOGA is not arguing that every molecule must be produced regardless of economics. NMOGA is arguing that the Commission cannot adopt rules that affirmatively and, importantly here, predictably cause avoidable waste. I'll leave it to IPNM to discuss the waste and correlative rights arguments in further detail. So on our last slide, which summarizes the action that NMOGA asks the Commission to take on each provision under review, on 27L6 to reject or affirmatively use the LFC's recommendation 750 BOE per year, but not use the definition to trigger unauthorized FA. On 89D to reject low producing well, one well FA as ultravires and is a violation of the $250,000 blanket bond cap. On 1589E to reject high risk portfolio, one well FA as ultravires and a violation of the cap. On 1589F to retain the 2-year TA threshold consistent with section 70-214A and reject the expanded scope of heightened FA. On 1589C through F to reject the flat $150,000 amount or recalibrate it to the statutory factors using post HB 80 data. On 1589A and 1599, we ask that the Commission clarify that the pre-approval language does not create or function as a property transfer authority. And on the compliance criteria, we ask that the Commission avoid overbroad gatekeeping that pulls in parts 27, 29, and 30, which we believe unlawfully causes waste. And on 19-15-25-9 and 15-8-9D, we ask that the Commission reject or delay the presumption of non-beneficial use and the low-producing well FA to avoid retroactivity, promotion of waste, and due process issues. NMOGA asks the Commission to adopt what the Oil and Gas Act allows, to reject what it does not, and to leave the rest to the legislature. I'd like to thank the Commission for their time in this lengthy proceeding, for their patience with the parties throughout. NMOGA certainly appreciates your consideration, and I'm happy to answer any questions.
Thank you. Not seeing any questions, so IPNM. Thank you.
Thank you, Chair Chang, Commissioner Bloom, Commissioner Ampoma. Thank you for your time. We appreciate all of the courtesies that you, the hearing officer, and Ms. Apodaca have extended to us. I would be especially remiss if I did not acknowledge counsel for the applicants and for the division for their highly professional, courteous, and friendly contact throughout. As Commissioner Chang observed, we were yucking it up right before we went back on the record, all of us. And I do appreciate that we've got contentious differences, but we've all kept it between the lines here, and I want to thank them. I agree with virtually everything Mr. Suazo says, but would like to concentrate my closing argument on some different issues, some of which Mr. Suazo highlighted. First, I intend to discuss an aspect of the rulemaking that hasn't received a lot of attention, but deserves your careful consideration. And then I'm going to spend the bulk of my closing on the reasons why this commission should reject the financial assurances portions of this rule, as it conflicts with the fundamental purposes for which this commission is charged. lacks crucial evidence in the case presented in critical areas, and is otherwise bad policy. And to Mr. Suazo's extensive list of what we did not stipulate to with the package that was submitted in applicants exhibits 89 A through E, we didn't also exclude that it's just not a good idea to adopt this rule. And I will concentrate some on that. We did and do appreciate the efforts of the parties. I think remove some of the sharp edges of the rules, made them more practical if they're adopted, but that did not address the fundamental question of whether they should be adopted in most instances. What I'd like to begin with is what one of my members called the new death penalty provisions proposed. Those are found in applicants exhibit 89B, and they're the changes to NMAC rule 19.15.9.5.9A, dealing with operator compliance. Current subpart 4 is a requirement that the operator be in compliance with financial assurance regulations, but allows certain tolerances for being out of compliance and not jeopardizing the operator's entire authority to operate. Applicants now propose to eliminate that tolerance so that one financial assurance violation will render an operator subject to elimination of its right to operate any wells in New Mexico. There was no evidence offered that an operator with a well or two out of compliance with FA is somehow taking advantage of the rule safe harbor and is more likely to abandon wells. There's no showing that the operators on the orphan well list took advantage of these tolerances. But on a more practical level, if this commission is inclined to adopt a rule requiring individual well bonding of low producing wells, it is counterintuitive to significantly increase the bonding requirements on operators and at the same time eliminate any tolerance whatsoever for financial assurance violation. This is especially true as during the hearing, the division took the position that it's possible for a well to qualify as low producing 1 year and not to be bonded the next year because production days or volumes of productions are increased. Subpart 4 and the changes thereto are not well taken. But even more egregious and completely lacking in any supporting evidence is the proposed new subpart 5, which provides that a single violation of venting and flaring rules would make an operator subject to complete loss of authority to operate. There's no evidence before the commission that one venting and flaring violation is somehow predictive of well orphaning. Indeed, a correlation doesn't make any sense. And it's punitive and excessive that an operator might be subject to its ability to operate multiple wells simply because it had a single violation. The proposed change is without any record support and should be rejected. Now I'd like to spend the bulk of my time on the financial assurances of the rulemaking. The Oil and Gas Act imposes on the Commission the primary or paramount duty of preventing waste and the related duty of protecting correlative rights of mineral owners to develop their oil and gas resources. In their case in chief, applicants admitted waste. Mr. Purvis's direct testimony was the financial burden of the proposed rulemaking would be painful to industry and stated that the rulemaking could put 90% of operators of low producing wells out of business. Operators, he said, would be misleased by the state. Ms. Fox now posits that because waste is, she says, Namoga said, I'm not familiar with the quote, that a molecule of hydrocarbons left in the ground is waste. And Mr. Ezel correctly said, operators are not going to operate under uneconomic conditions, that any amount of financial burden added to an operator's operating does not create waste under that definition or can't be missed. I don't understand the argument. It's contrary to Mr. Purvis's testimony for sure. The rulemaking and imposing financial assurance requirements will cause additional wells to be orphaned in the short term. And I think all of the parties in their cases that they presented to the commission in October, November agreed. Instead of preventing orphan wells, as applicants claim, the proposed wells will cause an increase. Mr. Purvis's missed the lease testimony so indicates he expects operators to go rapidly out of business. OCD exhibits 21, 22, and 23 are each lists of slightly different lists of 3,000 plus wells that are unplugged, and everyone seems to agree includes wells that are at risk of being orphaned. IPA&M offered testimony that 19 of those operators are responsible for about half of the wells on exhibit 23, which are 3,600 wells on the exhibit. And it indicates that there should be no reasonable expectation that any additional bonding will be forthcoming from those wells. Most of those operators are already on the master orphan well spreadsheet. Others have gone through bankruptcies and don't exist. On cross-examination, Mr. Powell agreed that there was not much reason to expect that many of the wells on those lists would be bonded if the rules were adopted. However, it's going to harm smaller operators, and Mr. Purvis tells us that. Dr. Arscott testified from his research that smaller operators sometimes post cash bonds. Most of those operators, and you heard from some of them, do their business planning on expecting lower profit margins than larger companies. They make their living buying, evaluating, maintaining, reworking, testing, recompleting, and improving older wells that produce at lower volumes. Dr. Arscott and Mr. Purvis agree that some of these operators are going to get put out of business if the financial assurance burdens in the proposed rulemaking are adopted. The harm to operators is even more acute when you move into the real world of the oil and gas business. Mr. Peltz was surprised to learn from my questioning that some operators don't even own an interest in the well. They're just paid a monthly fee for their services. All wells have non-cost-bearing interests in royalty or overriding royalty who get a percentage of well revenue, and they don't pay any expenses. In most wells, there are more than one owner of a cost-bearing interest, and the operator only has some interest in the well. However, as Mr. Exel explained in some detail, wells in New Mexico are almost universally operated under standard industry form operating agreements and form accounting procedures. Those contracts place all of the financial obligation for procuring government-required bonds on the operator, for which, among other expenses, including financial assurances, but not just financial assurances, the operator is compensated by a fixed, defined overhead charge that's not going to change based on the FA rules. With all the cost of financial assurance for slow operating wells falling on operators who may own only some or maybe even none of the interests in the well, Mr. Ezel correctly predicts chaos. The evidence is that Colorado's experience with dramatic financial assurance increases bears out that the parties' predictions. First, in Colorado, the number of orphan wells increased in a year almost fourfold. Second, the number of operators operating wells in that state has decreased dramatically. Applicants' response in their case in chief was not that this waste is not going to occur, but that it's not statistically significant. In particular, using the incredibly high, previously unimaginable present production volumes from New Mexico today, they claim that less than 0.5% of the production in the state will be impacted. As IPA&M witnesses explained, just going back before the shale revolution, you're talking about a lot more production, but still, 5% or so. Either way, Mr. Purvis estimates the value of lost production at over $50 million a year. The problem for applicants in this commission is that the commission's duty is to prevent waste, any waste. There's no asterisk by that term in the Oil and Gas Act that allows for millions of barrels of annual production to be wasted simply because it's not statistically significant in some people's minds. And that waste will continue into the future. IPA&M presented a number of witnesses who testified about low-producing wells becoming more productive with individualized attention. Several IPA&M witnesses testified about acquiring a larger company's non-strategic wells that produce small amounts, and with individualized attention, the smaller operator can pay to have the properties restored and realize additional production and profit. The IPA&M witness testimony was uniform that these sorts of transactions were multi-well packages, change hands from large companies to smaller, would completely dry up or be greatly restricted. And in fact, there's testimony that this proposed rulemaking, unenacted, was already chilling such transactions. All this waste will result in a concomitant impairment of the owner's correlative rights to produce their oil and gas. Premature abandonment or early plugging and abandoning of a well, or walking away from a well and orphaning it, will impair the ability to produce and derive economic benefit from the minerals. Waste is also going to be created and correlative rights impaired by rendering it less economic, if not totally economic, for operators and other owners to hold well while planning for secondary and tertiary recovery units, multi-well workovers, or recompletions and other strategies that are in the record and there is substantial evidence to justify. IPA&M appreciates that, for instance, applicants in the division worked with industry to make improvements to the temporary abandonment rules. However, the financial assurance burden that they propose to enact remains. While the rules would create waste if adopted, there's a notable lack of evidence that the rules will prevent well orphaning. The financial assurance rules proposed can only address orphan wells in two ways. First, if the cost of compliance with the FA rule forces an operator to plug a well that would otherwise have been orphaned. However, identifying such successes is not in the record. More to the point, the premise is improbable. Applicants in the division provide no evidence or rational explanation why an operator would pay to plug a well that it was later going to orphan, i.e. not paid to plug. It makes no sense that they would. Operators who produce little or nothing are not more likely, if they're going to orphan those wells, are not going to be likely to pay for financial assurances when the well is producing more but under the thresholds proposed. The second and only other way that orphan well burden could be alleviated by the financial assurances wells if those wells are orphaned with the bond of $150,000 in place. In those instances, after the division plugged the well and paid the contractors from the reclamation fund, it could seek to redeem the bond. I pressed Mr. Purvis on cross-examination about the ability to quantify any such benefit to the state of New Mexico, and he admitted he didn't have any, other than misciting some of Dr. Arscott's testimony, where Dr. Arscott quantified the total cost of compliance if there was 100% compliance of industry to the proposed rulemakings, not predicting it. In the end, Mr. Purvis's testimony was that he, quote, hoped, close quote, that the rules would result in the state being reimbursed by the financial assurances being mandated or proposed to be mandated by this rulemaking. That thin reed of hope is not an appropriate basis for mandating the hundreds of millions of dollars of new financial assurances that Mr. Suazo described earlier. Indeed, applicants' lack of evidence to support the benefit of the state from these rules is even more telling, given their repeated reliance on financial assurance rule changes in other states. Despite citing the increases in Texas, Arkansas, Colorado, and other states, there's not a shred of evidence that any of these states experienced better orphan well outcomes than they would have without the change. There is no evidence that any of these states' public fisc was better protected. There is no evidence indicating that the states with larger FA requirements have a lower rate of orphaning or a lower rate of government funds expended on orphan wells. There's only hope for better options. I'll return to that hope in a minute, but I want to emphasize lack of credible evidence in another area, the availability of sufficient surety products to satisfy what will be an extraordinary increase in demand. Industry presented evidence from individuals involved in the financial assurances and surety markets. Their testimony was consistent. The number of companies offering surety products to the oil and gas industry is declining. The ability of the surety market to provide so many single well bonds was uncertain. pricing and premiums would probably be higher than it is for current products if there's single well bonding. And there likely would be collateral requirements imposed and increased eligibility scrutiny for operators. You heard from some smaller operators who do not get their closely held entities audited that they're currently ineligible for surety products and have to post cash bonds. In contrast, applicants presented Mr. Morgan's testimony. Unlike the industry technical witnesses, Mr. Morgan has no surety or insurance market experience. His premium rate predictions, as Commissioner Bloom noted in his questioning, mistook apples for oranges, drawing from the cost of multi-million-dollar offshore bonds and equating that to some cost for a product that doesn't exist. His testimony about the availability of single well surety instruments of $150,000 was an optimistic capitalist take. If you create a market demand, supply will result. That is two crucial areas where applicants' case basically comes down to hope and prayer that single well bonding will actually make some material difference to the orphan well issues they forecast, and that there will be a robust market for surety instruments available to New Mexico operators. Build it and they will come was a great premise for a movie about a baseball field in Iowa. It's not a basis for policy. It certainly is not a basis to saddle industry with huge, painful costs with some unknowable possible future benefit to the state. That said, and it's not just in their closing briefs, industry is concerned about well orphaning and how to address the issue. In fact, decades ago, industry consented to the conservation tax exactly for that reason. The question's what to do about it. And we told you in November what we intended to do about it, led by Representative Murphy, who testified to you that both houses of the New Mexico legislature unanimously passed House Bill 80 in the past session, and the governor signed it into law. We've discussed previously what it will do, but it's based on a tax that every participant in New Mexico oil and gas production except two pay, and nobody else pays. Those two participants who are excluded are the state of New Mexico as a royalty owner and the United States government as a royalty owner. It's a tax on the value of severed production. And for a period, all of that tax went into the reclamation fund. As we discussed during New Mexico's budget crises of some years ago, most of that tax was diverted to the general fund. The fact the general fund was raided and industry's solution was refund the reclamation fund because, correct, I think Ms. Fox mentioned it, we can't predict who's going to orphan wells. I can't predict for you. I'm sure Mr. Tremaine and I could sit down over a beer and go over some lists and tick off some of the operators we think are going to do it, but we can't predict where the well orphaning is going to come from. And industry solution decades ago and today was create a reclamation fund taxed on all of us, and we'll pay for it with that fund. We consented to the tax, and now, again, the legislature has corrected past wrongs and is redirecting money to that fund. Using the much debated plugging cost of $1,500 per well or $163,000 per well, that's over 6,500 wells that can be plugged in the future, far more a higher figure than the applicants have cited or the 3,000 to 4,000 well figures in the LFC report. In addition to solving the orphan well problem, leaving wells unplugged that the applicants identify, I think HB 80 ought to inform this commission in two prudential ways. First, a great deal of time in these proceedings has been devoted to the commission's authority to enact FA increases, and I'm not going to revisit those arguments for even a second, even though I join in Mr. Suazo's and Mr. Rankin's arguments. The situation has changed since we concluded the hearings in November. The policymaking body of the legislature and as approved by the governor has spoken forcefully on the issue of orphan wells, and they did so not by seeking to impose new FA requirements or any new restrictions on industry. They adopted HB 80 to aggressively increase the reclamation fund. This commission is empowered to execute policy as expressed in enacted legislation. Applicants and the division saw a policy issue that they believed was not being addressed and asked the commission to fill the void. Even if you do believe that the commission has the power to enact the proposed rulemaking, it is a policy response that's inconsistent with the response of the legislature, which is the body charged, subject to gubernatorial authority, to adopt policy. Second, all of this rulemaking, if adopted, is going to impose new burdens on the division. We've heard that from all sides here. Please ask yourself if you should impose more. The LFC and its report and some of my witnesses were critical of the division's management of the reclamation fund. With the enactment of HB 80 into the law, the division is going to have to gear up and get more wells plugged. It has room for improving. Industry's happy to sit down informally and talk with the division about how they might consider improvements. But the question is, should the finite resources of the division and its employees be diluted by administering new FA requirements, by imposing new requirements on well transfers? IPA&M submits that the answers to those questions are no. There's a lot of comments that have bemoaned industry's failure to plug wells. And in fact, even here in the closings here, you see operator and industry go back and forth and used interchangeably. But industry did not cause Kano Petro's bankruptcy and the abandoning of hundreds of wells. It didn't cause the circumstance that led Ridgeway, Arizona, to have the inability to address its obligations meaningfully. However, the conservation tax is paid by all of us in the industry who produce oil and gas, and industry is going to take care of the problem in that way. In the areas of financial assurance and otherwise, these rulemaking proposals will impose significant or painful financial burdens on industry. Everybody agrees on that. The argument goes that the looming orphan well crisis justified these costs, notwithstanding the absence of any evidence that the proposed solution will actually work. Now that the crisis has been addressed in a way that we know will be more efficacious, funding the reclamation fund that the LFC identified as inadequately funded. Let's get to the business of making the reclamation fund work better for the division, the state, taxpayers, and industry, and put a rule that likely exceeds the commission's authority, runs contrary to recently affirmed legislation and executive intent, and is demonstrably structured to fail or fall short of its goals behind us. Thank you.
Thank you very much. Commissioners, Commission Council, any last words? Hearing none.
No, Mr. Chair, thank you.
Very good. Thank you all very much. Oh, great.
Excuse me, Chair and Commissioners, just one outstanding matter. I wanted to draw your attention to the motion to exclude that we filed recently.
1 second. Do you mind just forwarding that to me real quick?
Mr. Chair, I can speak to it briefly.
And just for my housekeeping, is that the only pending matter? Unconsidered. Okay. All right. Please, hearing officer, please advise.
I did check the reference to the transcript, and in fact, on November 6th, I did speak the words that the record was closed. I also checked the date that the letter was submitted to the administrator, and in fact, that was November 7th. I haven't, though, seen anything from NMOGA or IPA&M in response to it. It's only been, I don't know, several days since the motion was filed. But unless they can point to some respect in which the record was left open that I've forgotten about, I'd be inclined to grant the motion, noting that they did present testimony by Mr. R. Scott and Mr. Emmerich, and that a public comment submitted after the record is closed should be excluded.
Ms. Hearing Officer, would you like to hear from NMOGA or other parties on that before issuing a ruling? In that case, so.
If we could do that right now, that would be great.
Yes, I'm fine with that. So I'll turn it over to Mr. Suazo.
Sure. Well, we calendared our deadline to respond to the motion to exclude as next week, I believe on the 21st. So that's when we were intending to file our response. I have not gone back and verified the hearing examiner's findings on that. I'm sure our team is looking on that. I think there's a draft of a response already for me to review, but I haven't sunk my teeth into the details as of yet. So we were anticipating we would have until next week to respond.
That's certainly fine with me, Mr. Chair.
Okay. In that case, we'll stick with and allow responses, and we'll just take up the motion, this last remaining motion when we reconvene to deliberate.
Yeah. While the hearing officer's here, are you going to prepare like a top 5 issues type of hearing officer's report?
Yes, sir. And it has been delayed by illness, but I intend to do that very soon.
Great. Thank you very much. Is there any additional housekeeping matters on this case that anybody can think of at the moment? Awesome. In that case, I think we're moving on from that from this particular case for today. Thank you all very much. The next item on the agenda for us is any potential updates on pending OCC litigation. Commission Counsel, is there any updates? Public?
No, they're not.
Thank you very much. Next item is other business. Commissioners, any other business that you wish to raise at this point? Hearing none?
No, Mr. Chair.
Hearing none. I will just note for the record that the next meeting is a special meeting that will be on May 26th, May 26th of 2026. We will be starting 1 hour later than usual at 10 a.m. Due to a conflict, scheduling conflict. So we will take up deliberations of the case number 24683 at that point. Thank you all very much. We've now reached adjournment. If I could have a motion to adjourn.
Mr. Chair, I so move.
Mr. Chair, second.
Any objections? Hearing no objections, we are adjourned. Thank you all very much.